Here, I appreciate you coming down today to go to this seminar. This is something that, as you all know, has become incredibly important incredibly quickly in our state. And so we hope to walk through the issues of medical marijuana and how we handle that in the workplace today, and at least put some people in front of you that can help answer some questions that I'm sure that you all have. And the cast of speakers we have today are just unbelievable. I'm really happy to have all you guys here. Some great experience from different angles into marijuana in the workplace. I'll be honest, when this passed, my first initial fear, and I see a lot of sheriffs in the room, my first initial fear is how are we going to handle law enforcement with marijuana being legalized to some extent in the state. And that quickly went away when I realized that fear is nothing compared to how are we going to handle management in the workplace for folks that have a legal, not a prescription, but a legal medical card to go get marijuana. How are we going to handle that? That scares me to death. That should scare everyone in here that's a manager. How do you deal with this? And I'm really glad that we're going to get some good answers today. First off, this morning we're going to have Erica G. with Wright, Lindsay, and Jennings, and Erica's worked also with the Attorney General's office, so she's going to provide some good advice there from that angle. Chastity Cypress will go next. She is over at Pulaski County, one of their staff attorneys, and has been dealing with how they handle it, even to the point, Chastity, of getting into your personnel handbook, correct?
Yes.
So she's been going through that. That'll be some good information. Many of you know Jason Owens, who's represented just about every county in the state in risk management matters and a lot of personnel issues as well. So we're glad to have him here. And then to close out the afternoon, we'll have Carolyn Witherspoon. She's not here yet, but she's an attorney here in town with Witherspoon, Cross Gunner, and Witherspoon. Miss Erica G., I'd like to go ahead and turn it over to you. While you're walking up here, though, I want to introduce the architect of a lot of law this last session that helps clarify and define how we are going to handle medical marijuana in this state. Representative Doug House up here. Representative House did yeoman's work. I know there were about 50 bills that were filed, 25 actually passed, roughly. Is that correct? In the session, so a lot of the constitutional amendment left gray area out there that Representative House and the legislature worked on trying to fill in those gaps and define things that we needed to have defined. So with that said, Ms. Erica, are you ready?
Yes, sir.
All right. Please join me in welcoming Erica G.
Well, thank you for the introduction, and thanks for the invitation to come and talk to you here today. You might not be surprised to hear that I've been doing a lot of these kinds of conversations with different groups around the state. So I know from experience at this point, there is a great deal of misinformation out there. Just about everything I hear from people is wrong. So one of the things that I want to focus on to kind of start this off today is what the law actually is. And so then your speakers that'll come for the rest of the day can give you some nuances about how to deal with that law. But let's start with an understanding of what it actually is. And I want to tell you from the outset, I am not an employment law attorney. I played one on TV much earlier in my career, but it's not my specialty anymore. I'm a regulatory lawyer. I do administrative law, and that is actually how I got into working with medical marijuana. So you should probably hold your detailed employment-related questions for speakers later on today. To just begin, the way that I got involved in this is the Arkansas Business asked me to write some articles about the issues when they were on the ballot in November. And so I did, and then it passed, and then people started calling me. And you've probably seen this in your own counties and your own communities. People are really, really interested in medical marijuana. There's a lot of people who, I've been personally very surprised by the types of people who have been interested in this and the people who are trying to get into the business. You may or may not be surprised by who those people will be. So it's come out of the woodwork. It's become a huge conversation, and please interrupt me whenever you'd like if you have any questions, or if there's something you'd like me to clarify. But, because I think that helps everyone, because they probably have the same questions you do. So, okay, so let's start off by beginning at the beginning, with the election and what that election looked like in, Arkansas. Can you go back to that first one? I don't know if you can see this, it's a little bit small, but you've got it in front of you here. 53.2% of the state voted to pass this amendment, which surprised a lot of people, but frankly, I think those people hadn't really quite been paying attention, because it almost passed on the last general election, which was a big surprise. So Arkansas, as many of you know, is the first southern state who has passed any kind of medical or otherwise marijuana legalization. So I think that's one of the reasons that there's been so much interest, is a lot of people in other parts of the country view it as a gateway to the South. So people are showing up from everywhere. But let's talk about the basics of what is in issue number 6, which is now Constitutional Amendment number 98. What it does is it legalizes the use of marijuana by qualifying patients, and we'll dig down into this a little bit. But it allows the formal designation of caregivers to assist patients. It authorizes 20 to 40 dispensaries to be set up in the state, and it authorizes 4 to 8 cultivation facilities. It does not authorize growing at home. That was issue number 7 that was thrown off the ballot. A lot of people were pretty upset about that. And it does not legalize recreational use of marijuana for any reason. Okay, so the way that this is set up, and I'll be completely honest with you, I don't think this was the best way to do it. And I've told many people that it's very complex, the way that the amendment set up the regulatory scheme. And in my opinion, unnecessarily so. But we've got 3 different state agencies who are involved in this. So there's the Department of Health, there's the Medical Marijuana Commission, which was created by the amendment. It did not exist before. Then we have the Alcoholic Beverage Control under DFNA. So each one of those agencies has its sphere of regulatory control. They overlap somewhat, which makes it even more complicated and fun. Let's look at the qualifying conditions. So, from what I've seen from other states, this is kind of middle of the road as far as what actually qualifies you to be a patient. Some states are far more restrictive. Some states have 70, 80 something qualifying conditions. So we've got primarily pretty serious conditions like cancer, hepatitis C, Crohn's, Tourette's. Then we also have, which some states do not allow, we also have intractable pain, which is defined as pain that does not respond to ordinary medications, treatment, or surgical measures for more than 6 months. Now, I think you can see, at least anybody over the age of 20, I think probably has something that you could qualify as intractable pain if you really wanted to. So potentially, that could be a very large number of people if they wanted to become qualifying patients. Let's go to the next one. So this is very tiny, and I apologize for that, but you do have it in front of you. And what this is this came from the state. It came from the Arkansas Center for Health Improvement, which took the all-payer claim database, which a lot of people don't know exists. But what it does is it takes all of the insurance claims and what those were for, and uses that information for study, for academic purposes. They took that information and they tried to figure out how many people might qualify to be a patient for medical marijuana. And it's important to point out that this doesn't cover actually everything. This does not include intractable pain. And just based on people's diagnosis and their insurance payment records, there's 541,673 people who could potentially be a qualifying patient. Obviously, not all of those people are going to be. No one really knows how many of those people might actually want to do it. There's been all kinds of guesses, all sorts of estimates. The state had to estimate it for purposes of figuring out what it might cost to regulate this. But I don't think anyone really knows. So, working numbers most people are using are somewhere between 20 and 50,000. But again, that's pretty much a guess. So, what this shows you and why it's got all these different colors here is where particular conditions are concentrated and which states have the most which counties have the most qualifying patients. So I can send you this in a larger form if you want to look at what your county is and you can't quite see it on there. Go to the next one. So this just shows you how those conditions break down. You'll see that the most common ones are peripheral neuropathy, cancer, and for pediatric patients, it's epilepsy is the most common condition. So let's talk a little bit about how to add qualifying conditions. There are groups who are working on this right now. The process, go to the next one. The process, one more. There we go. The process to add a qualifying condition, the Department of Health does have the authority to add to that list. And they set up in their rules, it's a pretty difficult process. They set a pretty high bar. You have to include evidence that's generally accepted by the medical community, which, as you might imagine, there's not a lot of that. The medical community is not terribly open to medical marijuana, so that might be a little bit difficult to come up with. But you have to have evidence that medical cannabis alleviates suffering caused by the proposed condition. Then there will be a public hearing. Then the director of the Department of Health will make a final decision on whether or not that condition should be added. And one thing I don't have on here, but that I think is worth noting, is that if the director denies a particular qualifying condition, the next time somebody submits it, they don't have to have a hearing. You can just deny it from that point forward. So I think the groups that are trying to add to this need to be a little bit careful about what they submit on the front end. Make sure they get as much evidence together as they can. So, next one. The Department of Health is also in charge of patients and caregivers. So, they will maintain the patient registry. The basic information you need to become a qualifying patient is to be over 18. You've got to have a state driver's license or photo ID, have written certification from a doctor. Now, this is one of the biggest things that people are very confused about. There are no prescriptions involved in this at all. The only thing that you need from a doctor is they just need to agree, certify, sign a form that says you have a qualifying condition. It doesn't have to be your primary care physician. It doesn't have to be, your oncologist if you have cancer. Did you get it to work? Thank you. It can be any physician who's licensed in Arkansas and has a DEA registration. So, a lot of people's next question there is, how are people supposed to know what they're supposed to use? Which is a great question, and we'll come back to this. But your doctor is not going to say, I prescribe that you take this many milligrams of THC on this schedule. No. You fill out this form, you send it into the Department of Health. They are taking applications online. They're making it pretty simple. And you pay $50, and then you can, once you get your card and the dispensaries are open, you can go in the dispensary and buy anything you want to, as long as it's within the limits, 2.5 ounces every 2 weeks. So minors can use under this amendment. A lot of people weren't really aware of that, I don't think, and are a little uncomfortable with pediatric use, but they can, as long as a parent or guardian gives written consent. So that is authorized. You do have to renew your patient registration annually. Even if you've got some kind of qualifying condition you'll have for the rest of your life, you've got to do it every year. get the doctor to fill it out, pay your $50. So, one question that people have a lot is, are doctors really gonna do this? There are a lot of physicians that won't, or at least won't initially. There's a lot, in the medical community, from what I've heard, there's a lot of concern about getting in trouble with the DEA for participating in this, even if you're just filling out a form. In Arkansas, you cannot get certification from a physician over video or telephone conference using telehealth. Some states you can. So I think that will, there won't be quite as many doctors who move into the state to offer the service to people because they'll have to actually be here. So that will cut down on it some too. I personally think that the entrepreneurs of the world are going to solve this issue, and it's not going to end up being a big deal. But we'll see. We'll see how that ends up. So, residents of other states, this is a kind of a reciprocity program. Residents of other states, if they have a card in their state and they're legal in their state, they can use that card in Arkansas. If they're here visiting grandma, they can go ahead and get a card. You cannot get a card if you live in Oklahoma, you have an Oklahoma driver's license, and you want to come to Fort Smith. You can't. You have to have an Arkansas ID or driver's license. And that's not in the amendment. That was put into the rules by the Department of Health, and it's been pretty controversial. The sponsor of the amendment has said that that's something he intends to challenge. So we'll see. We'll see what ends up happening with that. So, caregivers. You have to identify who your patient is. You have to pass a criminal background check, which patients don't have to do, but caregivers do. Another $50 fee, and again, that has to be renewed annually. So caregivers can be anybody. It can be the parent of a minor child, it can be your friend, it can be your home health nurse, it can be anyone, as long as you designate them and they can pass the criminal background check and get registered with the state. One thing I don't think we covered later. Hold on. No, we'll get to it in a second. Okay, so they have in the rules reasons why applications will be denied. Probably the biggest two that I expect will come up is a physician did not have a physician-patient relationship, a proper physician-patient relationship with the patient. And one of the reasons I expected this could be an issue is this has been an issue in a lot of other contexts in Arkansas. Arkansas law on how to create a proper practitioner-patient relationship is a lot more, there's a lot more to it than other states require. Like, in most circumstances, you can't do it over video, you can't do it over the phone. It has to start off with a physical, one-on-one interaction between the doctor and the patient. Am I scratchy? Am I moving too much? So that's one thing that I think could be an issue, especially if there are a lot of physicians who come into the state and set up a booth at a fair or something to certify patients. Also, if the application or certification is fraudulent or falsified. I think that person who lives in Oklahoma who makes up an address in Fort Smith, I think is probably who we might be talking about there. So, confidentiality, this is a big issue. This has especially been a big issue for people who are looking at this from an employer standpoint from my previous conversations. All information regarding patients and caregivers is confidential. So, if you are an employer and you want to know whether your employee is an actual legitimate qualifying patient, the Department of Health will not tell you. They can't tell you. It can't be released under the Freedom of Information Act. The Medical Marijuana Commission and the ABC, the other two agencies that are involved in this regulatory scheme, they can access that information, and also the Department of Health can verify your registry status to law enforcement. But that's it. So everything else about it will be kept confidential, which I personally think might have some unintended consequences. So, any questions about patients or caregivers before I move on? Everybody's got it? Yes, sir.
So if law enforcement is, I'm sorry,
Oh, I'm sorry, I should have told you. Wait for the microphone.
law enforcement is checking with the Department of Health, due to a traffic accident or something like that, is that what we're talking about? But you can't just generally find out if they're registered, you understand my question?
I think I understand your question. They can verify the status for law enforcement, but you couldn't, for example, go in as a law enforcement agent and get all of the information about that patient, what their qualifying condition is, everything else about it. They can just tell you yes or no. This
Yes or
person
no.
is a qualifying patient or this person is not. Okay, so let's talk about cultivation facilities. They authorize 8, the Medical Marijuana Commission, who is in charge of determining how many will be issued and who they will be issued to. They decided to issue 5. So they might issue more in the future, but for now, they're only gonna do 5, and it may only ever be 5. Facilities will serve as the source of all products in Arkansas. Dispensaries in Arkansas cannot sell products from another state. It all has to be grown here. People have asked me that a lot. Will I be able to get XYZ that you can buy in Colorado? The answer is no, unless they make it in Arkansas. There are not a lot of rules about where these facilities can be located, but the rules that are there in practicality are actually make it a lot more limited than you might think. Cultivation facilities can be located anywhere except within 3,000 feet of a existing church, school, or daycare. That really cuts down on the number of locations if you think about how many churches, schools, and daycares there are in the state. Especially 3,000 feet is pretty far. Dispensaries are 1,500 feet, which we'll get to in just a minute. But there can be some zoning requirements that are put on cultivation facilities and dispensaries, but they have to be zoned the same way as retail pharmacies, which puts some limitations on what you can do there unless you want all the Walgreens to be on the outskirts of town. So, cultivation facilities can't participate in retail sales. They can do just about anything else. They can grow, they can process, and they can sell to dispensaries. So let's talk about what the application requires. There's a lot of misinformation about this too. How much money do you actually have to have? You have to, bare minimum, you have to, that's a lot of information. Bare minimum, you have to have $1 million in assets or a surety bond in that amount. You have to have proof of $500,000 in liquid assets. You have to pay a $15,000 application fee, and you'll get half of that back if you don't get the license. And then if you do get the license, there's a $100,000 licensing fee and a $500,000 performance bond that you've got to put up within 7 days. So it's substantial. I mean, it's a substantial requirement. And part of the reason for that, I can tell you from observing the Medical Marijuana Commission's discussion about this point, is they wanted to make sure that the 5 facilities that the entire market was going to be built on were owned by people who could actually do it, that they have the resources to do it. Build the building, get all the equipment, and stay in business until the market is actually going. So, I've heard a lot of people say things like, and there are a lot of people at the commission meetings who said this from in the audience, all it really takes is $15 worth of pots from Home Depot in a garage. A lot of people said that. Some of you might be thinking. It's the modern medical marijuana cultivation is far more complicated than I'll tell you I ever thought. The fact that there are so many states who have preceded us in this means that it's gotten extremely high-tech, and it takes a lot of money. Most of the cultivation facilities are looking at something in the 2 to 5 million range to put into their facility and to actually get going. So that would give you a little bit of a picture of what one of these places might look like. I should put some pictures in. I haven't done that. So dispensaries, then there's authorized to issue 40. They've decided to start with 32. They're going to keep 8 in reserve and see what happens. So they the commissioners divided the state into 8 geographical regions. And there's been a lot of questions about how they came up with these zones. I was there, I'm still not completely sure, to be completely honest with you. I thought, a lot of people thought, they were gonna take the 4 congressional districts and divide them up that way, because those are divided by population. So they're not equal geographically, but they're equal population-wise, and the dispensaries are supposed to be put where the patients are. So that's not what they did. They subdivided it further into 8 zones that are kind of equal in population. So, and I'll show you a map of those. And you've got it here. I don't know how well you can see, but you can see what I mean by roughly equal in population. Some of the zones are geographically much larger than others. But what the commission is going to do is they're going to take those 32 dispensaries and they're going to put 4 in each zone, no matter how big the zone is geographically or population-wise. So there are going to be 4 in Zone 5, Faulkner, Pulaski, Lonoke, and White counties. There will also be 4 in this entire Zone 7 area, which I think you'll all agree with me is a much smaller population. So that's the way it's going to be broken out. There is not going to be, as part of the application, they're not going to look at where specifically you are in the zone. That's not going to be part of it. As long as you're in the zone, that's the only geographical information that the commission is expected to look at. So let me go back here just a second. Dispensaries can't be located within 1,500 feet of a school, church, or daycare. So that's not quite as far as cultivation facilities. It would be more similar to the existing rules for liquor stores. So, and the zoning, as we talked about before. So let's talk about dispensaries. They have pretty broad authorization for retail sales to patients. Some states have limited the types of products that can be sold. Arkansas really hasn't, and we'll talk in a minute about what those limitations are. But just as a basic prospect, any type of marijuana product can be sold. And if you're like me, you might not know what that even looks like. Like, what are the different types of marijuana products? It's far, far beyond what you might be thinking of from a Cheech and Chong movie. Actually, I think that's, for the most part, smoking marijuana in a joint or a pipe or a bowl is actually not very popular anymore. What is more popular is all kinds of edible forms. Concentrates, oils, resins, food of different kinds, little gummies. Little gummies are very big. Candies, all kinds of things like that. A lot of people really like edible forms. They don't want to smell like it. They don't want to smoke it. There are a lot of vaporized forms that are becoming very popular. Pre-filled vape pens used for specific purposes, like to treat pain or something like that. There are a lot of topicals also. Creams, oils, and none of the topicals are going to have a psychoactive effect. So it's a much, much broader world than I think most of us who don't live in a state where this has been legal have ever realized. So they can sell any of those. They can sell Paraphernalia, as long as it does not require combustion to be used, and that was something that was changed in the legislative session. So they will not be selling pipes, bongs, rolling papers, things like that. They can engage in wholesale sales to other dispensaries. They're also authorized to process marijuana, which means turn it into all those other forms. I know there's a lot of dispensaries who are looking at doing that, really specializing in that. And they can grow up to 50 mature marijuana plants and seedlings. Go ahead.
There is a limit, it's not an unlimited amount of immature plants and seedlings.
You're right.
It's 150 by the ABC rules.
Thank you. He's right. You want me to tell him who you are? Cross that out. It's not unlimited. It's 150, as he said. So, and the ABC rules has defined what a mature plant is. A mature plant is one that's in the flowering stage. And we can talk as much as you want to about the different stages of cultivation if you want. But it's a plant that's in the flowering stage, which is a very defined stage in the way that marijuana is cultivated. So, dispensaries will be chosen on merit-based criteria. And I skipped over this part when we were talking about cultivation facilities, but let's spend a minute on this. The merit-based criteria that the commissioner is going to use to determine who gets these licenses is extremely extensive. It's very comprehensive. Those of you in law enforcement will probably be happy to hear this because applicants for both types of facilities not only have to identify the location they're going to use, they have to prove they have permission to use it for that purpose from the owner. They also have to have a complete floor plan, identify all the different areas, even if it's a building that doesn't exist yet, a building that they want to build. They've got to have a total operational plan. If they're cultivating, they've got to explain to the commission exactly how they're going to cultivate, what they're going to cultivate, how many they're going to cultivate, who's going to do it, what kind of pesticides or other chemicals they might use, what's their plan for testing, make sure purity and potency that's established by the Department of Health rules. I know there's lots of things that I'm leaving out. It's a tremendous amount of information, which from what I understand, and this could possibly be wrong, but from what I understand, is far beyond what any other state has really asked for. So they want applicants to not only have the money, but to come in with a fully fledged, this is how I would run this business if you let me do it, plan. And security as well. You've got to have all the security information. What equipment are you going to have? Where are you going to put it? Who's going to be in charge of security? How are you going to retain your records, etc. And you've got 25 pages to do it, plus an addendum. So the commission is going to read through all of these applications, and they are going to score them based on this criteria, and that's how the applications will be determined. So, for dispensaries, each geographical zone will be separately scored for each of those 8 zones. And so the best ones for each zone are going to be the ones who get the license. And because the only geographical aspect of it that matters is the zone, they might be all in the same city. It's not impossible. I think we all probably hope, including those people who get the licenses, that they're not all in the same city. That would not be ideal for competitive purposes, but we'll have to see how that plays out. So to apply for a dispensary, you've got to have $200,000 in assets or a surety bond, $100,000 in liquid assets. You can see it's a much lower bar than a cultivation facility. And the application fee is $7,500. So the license fee is $15,000. And the performance bond that's got to be submitted within 7 days along with the license fee is $100,000. So one of the main things that was changed in the legislative session about the way dispensaries are run is this bill that created something called a pharmacist consultant. And this was something that was introduced and advocated for by the Pharmacists Association. So, this is the person who's gonna fill that gap, or at least fill some of that gap between the patient and the product. Since the doctor is not doing that. The pharmacy consultant is intended to help with that. So they will develop educational materials, procedures, and policies. They'll do training for the staff, and they will also have to be available to consult with patients and the staff anytime the pharmacy is open. Now, they don't have to be there in person. They can do it by phone or by video conference, but they have to be available. So every dispensary will have to have a pharmacy consultant. So I can tell you there's a lot of scrambling in the pharmacy community of people trying to quickly get up to speed on medical marijuana, because that's not something they were taught. And it's certainly something that they can get up to speed on, but it's been kind of interesting to watch. So the timeline. Have started accepting applications. Last I heard, no one has submitted one yet. It's a 90-day period though. So actually this is wrong. Sorry, this is old a little bit. It's not October 1st that the application period closes. It's actually September 18th. The wild card here in the timeline of how long this is all going to take is how long the commissioners take to read through all the applications. They haven't set a deadline for themselves to read through all of them and score them. I think they're gonna get a lot more applications than maybe they realize, and I think it could take a pretty substantial amount of time. I mean, all 5 of these people have actual jobs, so, and other responsibilities. I think it's gonna be pretty difficult for them to actually get through them all. But best case scenario, being optimistic, somewhere around the end of this year, or the beginning of 2018, the dispensaries and hopefully the dispensaries and the cultivation facilities will be chosen, and then they can begin. Some of them will have to construct new buildings, some of them will have to rehab buildings, most of them will have to do something of some substance construction-wise in order to actually get open. And then the cultivation facilities have to actually grow the plants, which most people say that process from beginning to harvest is, you're looking at 45 to 90 days, depending on who you ask. So probably it will be spring of 2018, maybe summer of 2018 before this is actually available to anyone. So those of you who are panicking, don't panic. You've got plenty of time to figure out how you want to handle it. I think there's been a lot of confusion about that because the Department of Health has started taking applications to become a qualifying patient. This is because they were required to, not because it's about to be available. It's actually a pretty long way away. And same thing when people have said that they've started taking applications. People think, oh, well, next month this is going to be up and going. We've still got quite a distance. So the Department of Health, we touched on this for a minute, but the Department of Health has set up requirements for the testing of this product to make sure that it's not something that's going to include a lot of harmful chemicals, or something that will be very important in Arkansas, have fungus and mold issues in the product, because this is such a humid climate. That's going to be a pretty big deal, I think. So they'll test for pesticides, moisture content, concentration of the different components of medical marijuana will also be tested and listed. Heavy metals. The products that are produced from the raw flower will also be tested. And all this information will be available to the patients. If anybody wants to see, who am I buying from and what do they use in their growing process. The label requires a lot of information. I can tell you it is a challenge to get this information on a label. But you've got to have the concentration, the harvest date, the name of the strain, the activation time. In other words, how long will it take before I feel it, which depends on what kind of product it is. The name of the testing laboratory, required warnings, and a universal symbol, which last I heard had not been
It's on
determined
the
yet.
health website.
It's on there? Okay, good. It wasn't quite recently. The labeling cannot contain any misleading statements, and they can't be attractive to minors. The labels cannot. That is something that is a theme you will see, particularly in the ABC's rules. It was one of the legislature's big concerns, is to make sure that it wasn't accessible to minors or attractive to minors, either in flavor, shape, packaging, any of the above. We're not gonna have cakes and brownies, cookies. I guess you can have cakes. Can't have cookies and brownies in Arkansas. Can't have any sort of food or drink that is typically marketed to children, or flavors. So you should not be seeing any sour gummy bears in a dispensary, because in my opinion at least, that would definitely run afoul of that rule. So it can't be shaped like animals, or vehicles, or people. No Flintstones vitamins, nothing like that. ABC is in charge of packaging, advertising, and marketing. So they, in their rules, they have put some parameters on what is allowed. They also can't promote transportation across state lines, display consumption, encourage use of an intoxicant. You know, some of the things that a lot of people have been worried about what our state might look like with medical marijuana, have really been addressed in the rules and the legislation. Cultivation facilities can't advertise to the general public. I don't really know why they want to, but they can. Let's see, am I almost out of time? Yes. Am I? So, here are some limitations that came out of the legislative session. Act 1024 is the one that created the pharmacist consultant. It also eliminated the combustible forms of paraphernalia from being sold. Act 740 mirrors to a large degree the Clean Air Act. So basically speaking, you can't smoke marijuana where tobacco cannot be smoked. It also can't be smoked around a pregnant woman, someone under 14, inside a vehicle, or a place that is likely to cause a person who's not authorized to use it to become under the influence, which is pretty broad. Certainly could be. Patients under 21, pediatric patients, which I guess is more than that, can't smoke at all. They have to use a different form, which generally they do. Mostly would take a pill or a cream or an oil anyway, but they're not allowed to smoke. Let's see, Act 593, which I'm sure you will hear more about later today, establishes some clarifications that employers were really looking for on how do we deal with this? How do we deal with a qualifying patient in the workplace? So you will get some more details about what that looks like. Act 479 prohibits members of the military or the Arkansas National Guard from being a qualifying patient or from being a caregiver. Unanswered questions, there are so many. We certainly don't have time for, but a lot of the questions that people have, there really aren't any answers for yet. We will have to figure out how Arkansas's existing laws will work with the medical marijuana rules. There's a lot of employment issues that are really not going to be determined until after people start suing, unfortunately. And there's a lot of interactions with federal law that really have yet to be figured out in Arkansas as well. So most of the questions people have really about what about this, there isn't really a very good answer to, unfortunately. But with that, I'll be happy to take any questions that you have, and we'll see if it's one that's got an answer. Yes, sir?
Are the insurance plans, are they gonna cover that?
No. It's not required to be covered by insurance, so I don't imagine that any of them will. It'll be a cash-based business. Anybody else? Yes, sir?
I know if a business wants an alcohol permit, they have to at least notify law enforcement in that area. Is there any such regulation if somebody's gonna open a dispensary or cultivation, if they notify law enforcement that it's gonna be in their area?
There is not a requirement, no. I think as a practical matter, most people will, because they don't want there to be any unexpected challenges from wherever their location is, but there's not a requirement to do so, no, sir. Anybody else? Oh, we've got two of you here.
I know there's a lot of open questions regarding federal law, but under state law, if you are a security personnel for a facility and you have a firearm, are you open to prosecution under state laws for use or possession of a firearm in furtherance of a drug crime?
It is not a crime in Arkansas under state law, as long as you're complying with all of the regulations surrounding medical marijuana.
So those,
Does that answer your question?
I think so. So
Federal law is a different issue.
Federal law is a very issue, but I'm talking about just state law.
You are not in violation of state law, as long as you're complying with all of the state's rules. You know, it's not gonna save you if you are a qualifying patient and you are driving around with a pound of marijuana in your trunk. You're not allowed to be in possession of that. So the fact that you're a qualifying patient is not gonna keep you from being prosecuted, for that possession.
Sorry, I do understand that. So if you have the amount allowed under the state law, and you're, say, going hunting, so you have a firearm in your car, then you are open to prosecution under state laws today, or you're not?
If you are a qualifying patient and you have marijuana in your car, not using it in your car, not under the influence in your car, but you have it in your possession, if you have the amount you're allowed to possess and you are a qualifying patient, you will not be prosecuted.
Regardless of firearms?
Do you? The firearm issue, as I understand it, is a federal law issue. And I honestly can't tell you right now what Arkansas State Police intends to do about concealed carry permits. I know that's a question a lot of people have, and it may be that someone else in the room has an answer to that. I don't have one as we stand here right now.
Have they set standards on trucking? I mean, if you have cultivation facilities, you've got to get it to the dispensaries. So what have they set up for that? Because someone's gonna have to move it. They-
Yes, you have to provide the commissioners with your plans for transportation. There was legislation that authorizes a new category of licenses for transporters for people who are going to specialize in that transportation. The commission hasn't issued those licenses yet. I expect they probably will. But as an initial matter, the ABC has got rules about how it's gotta be transported and what the rules are about, for security and make sure that it's not diverted from lawful use. And the applicants have to have a plan for it. Yes, sir.
I'm just gonna build on that just for 1 second, and just ask you a question, based on your response. 2.5 ounces every 2 weeks is what you said a patient can get, right?
Right.
So in states where it's legal, it's about $15 a gram. So 2.5 ounces equals 70 grams. So on a yearly basis, one patient has to come up with $27,300 to support this. If they're not paying for it from a law enforcement perspective, where are these people gonna get that kind of money? And that's one of many questions that we have. Where are they gonna come up with the money? Are they gonna steal? Are they gonna, I don't know.
I think it's a great question. So, first of all, I'll say the commission has encouraged dispensaries to come up with a compassionate care plan to help patients who can't afford to have some sort of sliding income scale. Another thing is that not everybody's gonna be buying 2.5 ounces. I mean, I certainly understand what you're asking, but not everybody's gonna want that level of intake. I mean, that's a lot for one person. And so I think from what I've been told, your average medical marijuana patient would probably be looking at spending something in the $100 to $150 a month range, which is a lot. I mean, it absolutely is. But for a lot of these patients, they are, at least this is the idea to some degree, a lot of these patients will no longer be getting hydrocodone prescriptions and paying all the co-pays to get those. So depending on who they are and what they use, it could balance out a little bit, but you're right. I mean, that expense is something that will be difficult for a lot of patients in Arkansas.
Policy. Maybe just by a show of hands, how many of y'all have drug policies in place right now? Most of you? How old are those policies? Are they really old? Yeah, I'm not gonna lie, Pulaski County, our policy, I don't think I'm gonna get this wrong, was written in 1989. And not many changes to that drug policy. We made changes, tweaks along the way to our employment policy, but not necessarily to our drug policy. So it was time to look at it and update it, and our goal from now on is to do that on an annual basis, and that'd be a good idea for y'all too. Not to mention, as Erica said,
Can you turn off this
can't,
there?
okay. Turn it up. Here we go. Hold on, closer to you. Can you turn this? Is this a volume? Okay, I'm gonna try and get it to me as close as possible. Can you hear me a little better now? Is that good? Okay, here we go. All right, so, as I was saying, we're just gonna look at this on an annual basis. It'd be a good idea for you all too. We're not sure how this is gonna play out. Since we don't have any cases yet, this is speculative, but it's a good guess on our part. And we sort of modeled our policy after DOT because that one is tried and true. It's been in the courts, it's been tested in the courts, and it usually doesn't fail if you follow it. So we modeled ours off that. Now we did tweak it a little, so we have a few changes here and there. And I'm happy to provide our policy to anyone who's interested. It's on the county website. We took that policy, we wanted to have a general policy that was applicable to the county employees at large. But then we're gonna have a few tweaks for people that are road and bridge, sanitation, and the sheriff's office when they have DOT testing that they've got to enforce in those areas. We're also going to have at least one tweak with regard to the sheriff's office so that they can test after there's been someone had to pull a gun and someone had to shoot. That's really not applicable to your employees at large, so they're going to follow our policy with a few minor tweaks. If anybody's interested in talking about that afterward, I'm happy to talk about it. I'm also happy to share our policies in all three areas. Okay, but they're all kind of modeled after what we're going to talk about today. So, next question. How many of you all receive federal monies? Do you get monies through grants? Almost all of us do. If we really think about it, we all do. A lot of your transportation money comes from the Department of Transportation. A lot of your money at maybe the courts, but also out at the sheriff's office comes from Department of Justice. All that money comes with strings. So some of the strings we're going to talk about first. We need to keep these in mind when writing a policy because you need to know what you've got to follow before you start writing. So we've got the Drug-Free Workplace Act. It was passed in 1988. I'm going to suspect that's why we wrote a policy in 1989. It has a lot of the requirements that were in the Drug-Free Workplace Act. I've been at my office 17 years, so that was before my time. I'm happy to say that. And it was modeled a lot after the drug-free workplace. So what you've got to remember is this is where it gets sticky. So we're talking about in Arkansas now, if you're a card-carrying member, you can have access to things that we didn't have access before. So the problem becomes that the federal law still says that's illegal. And under the federal requirements, when you're receiving federal money, you still have to at least potentially have the ability to discipline your employees if they're in violation of federal law. So they have not changed this. Maybe eventually when more states adopt this, they will make a change, but as of right now, we still have this workplace in the Workplace Act in effect. And if you're receiving federal monies, you need to be wary of it. So it's actually applicable to federal contractors as well as grant recipients. So what it requires is that you publish a policy, which is what we're talking about today, and you have to inform all of your employees of the policy. And you've got to inform them of what's unlawful and the consequences if they violate your policy. So put it in writing, train on it, give them a copy of it, make it available on a website if possible. Get them to sign off that they've received your policy, and you have an acknowledgement in every personnel file. If you're doing that, you're probably okay with regard to this. But you certainly don't want to lose your federal money or have it suspended or go on the list where you can't even apply for federal monies for a 5-year period. That's the last thing anyone wants to have happen, so don't let it happen to you. You've got to write into your policy that employees have to give their employer notice within 5 calendar days if they're convicted of a criminal drug violation in the workplace. This really isn't that hard to comply with. You're pretty much going to know if your employee's arrested in the workplace because they are under the influence or they have a possession that's over the limit. You're going to know that, so this isn't that difficult to comply with. But within 10 days of receiving that notification, you've got to turn around and notify whatever federal agency you're receiving money from that that's happened and there's been a conviction in your workplace. So the notification is important. Write all this into your policy, and then if and when you have to deal with it, just pull out the policy. You've got to be able to impose a penalty. Now that's up to you. It doesn't dictate what your penalty has to be, so it's up to you what you're going to write into your policy. And you've got to make a good faith effort to continue. So look at it every year. Make sure you're in compliance. If it came up during the year and you had issues with it, then you might want to tweak it for the next year. Okay, so what are some other considerations beyond that one? That's a big one. When you start talking about pulling our money, we all start paying attention because none of us can afford to lose those funds. So the biggest consideration after that, I think, is the Fourth Amendment. Most of us here are in law enforcement or deal with law enforcement, so we're very aware of the Fourth Amendment. And if we think of it in terms of, in order to go out and make an arrest, usually, unless something happens in front of you, you need to have probable cause to go make that arrest. Well, a drug test is a search within the parameters of the Fourth Amendment. So before you conduct a search, you need to make very sure that you either have some sort of probable cause, which is usually referred to as reasonable suspicion, or you're aware of another factor that would kick in and allow you to do that test. If you don't have that, you don't need to be doing the drug test. You'll end up in court and you'll likely lose. Okay, so basically this happened in the 80s also. The Supreme Court did a series of cases, and they kind of gave us the parameters of how we can drug test. So they want to know, it's a balancing test, and they basically want to know if there's a compelling governmental interest that outweighs an intrusion into your employee's privacy. And I just noticed there's another typo up here. Apologize for that. I did this about midnight and sent it in last night, so the Supreme Court wants my brief worse than they want me to put together a presentation. So basically, we just need to make sure that we have a reason to drug test someone, and your policy needs to reflect that. So if you write a hard and fast policy, it's easier to follow, and you don't have all these questions, and everybody's wondering what will happen. It should be in writing, and you'll know what will happen, and you'll know when to apply it. Okay, so basically they're saying some of the things that they look at are, is there a documented drug or alcohol problem in that particular group? None of us are really going to have this so much. This seemed to be a big deal in one of the cases that I cited here, so if you want to go back and read about it, feel free to go back and read about it. But it was with train operators. They were able to show that there was a real problem with train operators, and because there was that problem, the court said, okay, it's okay to test everyone that falls into that category. That's okay, you don't need to tell us anymore. We understand there's a drug problem, and you're allowed to test. Some of the other ones are no-brainers, or it would seem to be no-brainers, right? Nuclear power plant, how many of us don't want that tested? I know I went by a nuclear one this past weekend. I really want those people tested. I live way too close to that. That's not something I want to have happen. Another one is customs agents who are directly involved in drug interdiction. So it means the frontline forces, or people doing the arrests, people who are undercover, working with detectives in drug areas. Also, we need to think in terms with this one, your people at your jails that are dealing with booking in, intake, patting down, search it, anybody who's dealing directly with your prisoners. hand contact with your prisoners. As much as we don't want to admit it, sometimes things come in. We find those things, we take those things. Those people also are going to fall into this category. At least we suspect they are, and we put them in ours. Okay, so next, we're going to talk about explicit employee protections. I was just talking earlier with Representative House and thanking him and others for their efforts in passing Act 593. This is really going to save us. Before this was passed, we were really in panic mode. What are we going to do? How are things defined? How are we going to put this into play? This really feels like a safety net, and that's what we're going to use it as until we end up in court and we try a few of those things. And let's be honest, everybody's goal here is to not be the first one in court with regard to this. So that's why we want a hard policy and we want it written well. But it does give us some protections as well as provide some protections for the employees. But basically what it says is that it prohibits all adverse employment actions against employees based solely on participation in the medical marijuana program. It does require showing of impairment before taking some sort of adverse employment action. We're going to talk about this a little bit more. I just wanted to bring it to your attention. That's one thing that we need to think about when we're forming this policy. Some other considerations that I probably shouldn't put at the bottom because these are biggies too, but due process and equal protection, two of the things that can come back to bite you and you really need to watch for. So you want to make sure that your policy, you make your employees well informed of the policy, and then you apply it across the board. So for instance, you've got an employee who seems to be a great employee, you're going to cut him a little slack. I know you want to. We all have been there and you want to do it. You've got to apply the policy across the board. The next time someone comes in, maybe not such a stellar employee, but they might be of a different age, race, national origin, sex, have a different religion, and you apply it differently, that's where you're going to get in trouble. You've got to have a consistent policy and it's got to be applied uniformly. As long as you do that, you should be okay. Americans with Disabilities Act. This is going to come into play more if you learn of your employee's disability and they ask for accommodations regarding the disability itself. You do not have to accommodate drug use in the workplace. Those are two different things. I just want you to distinguish the two things, know that it's there, and if they're asking for accommodations, for instance, let's think they have cancer, and they're coming in, they need to come in late or leave early to go receive a treatment, and they perhaps won't be in the next day because it causes vomiting. That's an accommodation. Them asking to use marijuana while they're in the workplace, that's not an accommodation. They are requesting accommodation. It's not required by law. You do not have to accommodate them in the workplace. So distinguish those two things in your head. The Arkansas Civil Rights Act, it protects against discrimination based on a disability in the workplace. Just be aware of it. Same sort of scenario that we just mentioned, but those are two things that you need to look for also. Okay, now let's get busy. Let's talk about how we're going to put this into play. So the types of testing, is everybody pretty familiar with these types of testing? And you've got to determine what kinds you want to do and how you want to run your policy. At the end, I kind of have an overview of this, but I might not have mentioned this at the beginning. We took a unique process here. We did this, we rewrote our personnel policy, the entire thing from beginning to end, drug only being a portion of that, and we did it via task force. Has anybody else been on a task force lately? Yeah, it was a good experience. We brought in people from the outside and the inside. We had HR professionals from Delta Dental who had been there a long time, from Blue Cross Blue Shield. We had people sitting on the task force, and it was a great task force, right? Made up of a lot of different interests. I tell you, I got a little envious because they're talking about, we drug test everybody. We drug test everybody when they come into work. We drug test them randomly. They can do so many more things than we can. We have to abide by the Fourth Amendment, and the Fourth Amendment's not a consideration when you're on the outside and you're not in a public sector. So the conversations were short with regard to that, and we really were all envious. But it made the policy a better policy. I'm suggesting you might want to get your elected officials in a room and talk about what you want your policy to achieve before you can really get down to the nitty-gritty of actually writing it. Otherwise, it's going to be a fruitless effort. You need to know where you're going and have a roadmap before you start trying to write. So these are our different types of testing, and we're going to go into more detail on each of these. with the next slide. So basically, with pre-employment testing, it's always performed after a conditional offer of employment has been made. You don't want to do it in advance of that. There's been at least one case that ruled that a wholesale testing of all applicants for government employment without regard to the nature of the position that they were hiring into is illegal. So you want to look for that. With us, we just decided it's a money issue also. And for the most part, pre-employment testing may or may not yield a lot of benefits. People may go a few days being clean, and they might test clean, and you've got to weigh the cost-benefit analysis there and decide if y'all want to do it for yourselves. With us, we decided we wanted to do it for our safety-sensitive positions, and we really focused on them throughout the entire policy. If you do that, you're really safe. If you want to start going off into other areas, you really need to think about it and talk about it with counsel before you make the decision to do that. Okay, so pre-employment testing should really only be used for applicants who qualify under DOT or another agency, and also for your safety-sensitive positions. It really is important, by the way, it's a little caveat, that it's really important and it's going to save you in litigation. You need to update your job duties lists. So if you haven't done that, your job descriptions, you really need to do that. These go hand in hand. Without those being updated and you naming positions in your policy as safety-sensitive positions, you're going to get yourselves into a lot of trouble. So make sure you update those and they reflect that they're safety-sensitive. If they don't reflect that they're safety-sensitive, this is not a safety net. So you will end up in litigation. Okay, now with regard to reasonable suspicion, it's done on an individualized basis, obviously. So you're looking for signs of impairment. And that's really what this is geared to. So uncooperated tips or hunches is not going to cut it. And we're going to we're going to look at a form and we're going to talk about what needs to be on that form. Make it really easy for your supervisors in order to do the checklist before you send someone for testing. And then you have assured that you have a reasonable basis to send them for drug testing, and you will be covered when it comes time to put someone on the stand. Okay. With regard to post-accident testing, we modeled ours after DOT. There's debate on this, and people want to do it in different ways, and that's perfectly fine. Just talk it out beforehand and know where you want to go with it. But you've got to be specific about this. And your policy should, I know I've said this 5 times already, but should really nail it down and stick to your policy. So when testing is overly broad, for example, you have 5 people in a car, and your driver, as well as everybody else, gets tested if there's an accident. What's the reason for testing everybody that was in the back seat? That's hard to defend. So make sure that it's not overly broad. Your drivers are the ones that you want to be testing, unless they get out of the car and someone shows up at the scene, and your fallback should always be reasonable suspicion testing. So if you get to the scene, and beside the car, there are beer cans, and everybody smells like a brewery, and their eyes are bloodshot, you know something's going on, more than one person in the car, then you fill out your paperwork and you send everybody else for reasonable suspicion testing, not necessarily post-accident testing. So always fall back on reasonable suspicion. Some people write into policies, we chose not to do this, it's really up to you, but some people write into policies that, say for instance, if you have an accident and it results in damages of $1,000 or over, that you're going to send them for drug testing. How many people have had an accident lately? Do you know how much damage is done to your car when you get out of it and you're trying to make a decision within an hour or two to drug test someone? I mean, do you have insurance adjusters on staff? We don't. It's a hard policy to enforce, and then there has been at least one court, it's not in the 8th Circuit, I believe this is the 9th Circuit, but still, there's been at least one court that said that that's an unreasonable basis to drug test off of. So, almost any kind of fender bender. I had someone run into the back of me recently, and I looked at it, car's drivable, it was an accident, a true accident. It looked like maybe $1,000 worth of damage. Turned out they had to replace the whole bumper. It's over $5,000. I mean, I would not have thought that when I got out of the car. So the point is, that's a hard place to enforce that policy, and if you want to go that route, that's okay. But really think about it and the number you're going to put on it, because you could end up having to defend that in court. We chose not to do that. That's one battle we didn't want to fight at this point. We may reconsider that. I've already had calls about this, actually. Last week, I received a call about that, and they go, well, we want to write that in. Well, let's talk, and we'll consider that. But let's see how many times that happens to us before we consider writing it in. Since it's not tested, it's best not to push the waters if you have to. That's just me being conservative. Some others may not share that viewpoint. Okay, let's go on to random testing. This is where everybody ends up in court. So when you're reading cases, it's generally with regard to random drug testing. Now, it's a great thing to have in place because it acts as a deterrent. People come to work, they don't know if they're going to be tested or not, so they really think twice about using drugs over the weekend or the Labor Day weekend. Yeah, it might make them think twice about it. But you've really got to consider the group that you're going to randomly drug test. So it's got to be a position that basically constitutes a sufficient public safety concern, such as operating heavy machinery, or again, we go back to drug interdiction or carrying a firearm. Those are clearly going to get you there. You know, you start getting a little more sketchy when you start talking about randomly drug testing. For instance, your mail courier, do y'all have those? We're kind of spread out in multiple buildings across the city and into Pulaski County. So we do have a mail courier, and that's all he does. He takes mail from one building to another, but he doesn't have passengers with him, and he's not really carrying anything such as firearms or anything that's of substantial. I mean, we all think our papers are very important, and they get shuffled around from one department to another, but it's really not a reason to randomly drug test him. So think about that when you're writing too. Again, make sure that you specify your safety-sensitive positions. That's where Act 593 is going to save you. They have written that in like a gift from God, and I say we use it. Okay, so at the bottom, I added in what we've considered safety-sensitive positions. It may be slightly different for you all. They're pretty much counties are the same. Some of us larger than others, but we have the same concerns. So certified law enforcement, carrying weapons, working with drug interdiction, 911 operators, jail deputies that have direct contact with prisoners, your mechanics. You can and should drug test your mechanics. So road and bridge crews, sanitation crews, and when I'm talking about crews, I'm even talking about our people who are out using power saws, cutting branches, setting up the cones on the roads. I mean, if they look the other way too long and allow a collision because they weren't flagging, those are safety-sensitive positions too. So we included those. We fully intend to test them. And your CDL holders. So DOT, as I said, comes with its own bag of tricks there, but you want to treat them slightly different under your policy, but they definitely are, of course, safety-sensitive. You can test them in two different ways if you choose to do that. It may be expensive. I believe the city of Little Rock does it, and we're kind of talking and tossing it around now, but you can test them under your standard personnel policy, and you can also test them separately under DOT. It means they'd have to do two separate sets of tests. Might get kind of tricky. According to DOT regs, they've got to be separate and distinct groups, non-DOT testing versus DOT testing. If you want to do that, it may be duplicative for you. We're just going with one for now. Okay, and then with regard to return to duty testing and follow-up testing, again, this is required by DOT, and it's a good idea to limit substance abuse depending on how you write your policies. Some of you may just terminate people if they test positive. Others might want to send them to EAP. It's up to you, and SAP if you're going under DOT regs. So a substance abuse professional, and then you've got your employee assistance programs, which were started back in the 80s, and that was pursuant to the Drug-Free Workplace Act. So it was required under the Drug-Free Workplace Act. Most of us put one in place, and we still have them, and they're great. But for more intensive, so basically your DOT people, the people who are true safety-sensitive people, you might want to put an SAP in place. It costs money, so and we are going to bear that expense. We've passed that on to our employee. It's quite expensive to go to an SAP, but it boils down to this. Do you want to keep your job or do you not? So if you're willing to keep your job, you're going to have to pay the money and go to, under our policy, and go to a substance abuse professional. It's a little more intensive, and they set up a regime of coming in for counseling and also testing. So in our policy, we wrote in under the follow-up testing, return to duty testing and follow-up testing, we wrote in that you'd have to follow the recommendations from the SAP before you can come back to work. So we won't accept you back if you haven't followed the recommendations. Might also be a way to limit the number of people that you're really going to have to keep up with afterwards if they tested positive somewhere. How do your counties feel about that, by the way? Just by show of hands, how many of you are under the impression that you all want to work with your employees if they test positive on a drug test and or an alcohol test? Do y'all have that written in? So you, at least one wants to work with their employees, and that's perfectly fine. And this is where it's important about how you write your policy geared toward your county, and then other counties may not want to do that. We personally, we chose to terminate when it's with regard to drugs, and if it's regard to alcohol, then it's at the discretion of the elected official whether or not they can, we wrote it in so that they can do anything up to and including termination, but it will be at their discretion as to how they apply that. We just are having lots of discussions about applying it uniformly. So as long as they apply it uniformly within that department, you should be okay. Okay, so let's move on. Does anybody have any questions about that specifically, or might come up later? Okay, so basically going to the medical marijuana amendment, let's talk about it one more time. In order to take adverse employment action, an employer must have proof that they either used in the workplace or they're under the influence in the workplace. So you can't just terminate, you're going to have a little evidence. So let's talk about how we're going to get the evidence. So this is where Act 593 comes in. It defines what safety-sensitive positions are. Now, this doesn't mean that you don't have to go in and tweak your job duty list. You do. This doesn't mean you don't have to write it into your own policy. You do. This gives you a guideline of how to write it into your policy. So, at least now we're all saying, we haven't tested this in court, but as of right now, if you follow their guidelines, then you should be okay. So, I can read this all to you, or we can just talk about it. It's pretty detailed. But if you fall under a federal agency's guidelines as being a safety-sensitive category, then you can test. You can list them as safety-sensitive because they obviously are. Those are without a doubt. We're not going to have problems with those. The next ones become the ones that we ourselves are going to define as safety-sensitive. We've already talked about some of those, the way we've defined ours. You all might have others you want to throw into the mix. If you think of some, raise a hand and ask about them. But for the most part, we can define them as a position that requires carrying a firearm. That one seems obvious. Performing life-threatening procedures, that also seems obvious. Working with confidential information or documents pertaining to criminal investigations. Again, we're really focusing on law enforcement here. Working with hazardous or flammable materials, controlled substances, food or medicine. I don't know how you all run your jails, but at our jail, we outsourced in November of last year our medical. So medical is no longer in-house, but before, if it had been in-house, we would have put them into this category, but we don't carry that anymore. We kind of rotate. We go about 10 years and then we'll bring them back in-house, and then we'll think it's cheaper to go outsource again, so then we'll flip and we'll put it back out. So depending on where you are with that, same with our food. We outsource our food, otherwise we might want to add them to the list because potentially they would be covered under this. So just depending on how you're set up and how your contracts are written, you'll know who falls into these categories. Okay, and we kind of have a catch-all about the lapse of attention. Like we were talking about earlier, the flaggers out on the roads, you can be creative here. It's not being that creative. It seems pretty obvious when you're talking about anybody that's in a position where a momentary lapse could cause injury to themselves or someone else. All right. The only thing that I left out of this in our policy regarding the motor vehicles, it did concern me that we were including them in the category. for public only, public employers only. Private employers, again, can get by with so much more, and they can define these more broadly. We've got to narrowly tailor our groups that we're testing in order to survive a Fourth Amendment challenge in court. So you've got to be very conscious of that when you're writing it. For that reason, as I've talked about before, just driving a motor vehicle in and of itself, I mean, I drive a motor vehicle to work, at lunch, to go home. It doesn't increase my risk of being involved in an accident than anyone else on the highway with me. So you've really got to think about how you're going to classify those positions. Just driving a motor vehicle alone, I don't think gets you there for government employees. But if you're driving a dump truck, of course. If you're driving a road grader on the side of a road, yes. If you have a, I don't know, you've gotten some DOJ money and your sheriff's office has bought large pieces of equipment for riots or anything along those lines, and it requires something just a little bit more than a normal vehicle, then I think you can put them into this category too. All right. Next, they've also defined for us reasonable suspicion. So when we're talking about what does it mean to be under the influence, because we all think we know what that means, but then when you go to put it in writing, it starts getting a little more difficult. They went ahead and took that burden off of us and put it in one place so that we can all rely upon it. So basically, we're looking at what's observable. Speech, standing, walking, physical dexterity, agility, coordination, actions, movement, demeanor, appearance, clothing. So if you're disheveled, that counts to odor, irrational or unusual behavior, anything that's inconsistent with your normal appearance and demeanor at work. Also, a general negligence or carelessness when operating equipment. So this is kind of a catch-all again. So you might not need to test them necessarily under your accident testing. You could also test them under reasonable suspicion if they're being negligent or careless while driving a car. So we've also got a disregard for safety, involvement in an accident, and anything else that we can put into that category. Kind of number 5 is a catch-all that shows that it has a negative impact on your job performance or your job duties. Okay, moving on. So, under the current law, you've got to show that you've got a good faith belief that there's been some sort of use either at work or they're there under the influence. So in order to get those things, they've given us a convenient list of the things that they already consider as proof that someone is under the influence or using at work. And so you can rely upon these things, but at the end there's a catch-all where we may add to this list as we start litigating this throughout the years. So you've got any kind of observed conduct, which is what we're going to base reasonable suspicion on that we just talked about in the slide before this. You've also got information that's reported to you, but it's got to be reported to you by a reliable person. So if you're talking to someone that you clearly know from past experience with that person that they have a bone to pick with someone, or that they're not really reliable, that's probably not going to cut it for this one. So it's got to be reliable. And written or electronic or verbal statements. So we're all guessing at what all these mean or how we can use these, but I'm thinking Facebook provides a lot of information here. So if anybody's been on Facebook lately, I avoid it like the plague. I use it when I'm going to court with someone else, but I avoid it for myself. So you can find a lot of good information on this, and probably that's one that could contribute to your good faith basis. So look at number 6. They actually list in a positive test result, but according to the amendment, you can't take action based solely upon a positive drug test. So you really need 2 of these, unless you're in that safety sensitive category where you can take action based on one of these. But it's always a good idea to have 2. If you've got 2, you should be fine in court, and that's where it counts. All right. So what are the things that your employee, we've talked about a lot of ways they can sue you under 4th Amendment, due process, equal protection, some sort of ADA claim. where are they not going to be able to sue you? They're not going to have a cause of action if they're trying to sue you for establishing a substance abuse or drug-free workplace policy. The law is encouraging us to have a policy in place and then abide by the policy. So you simply establishing a policy that would take disciplinary action against an employee if they violate it, that's not a cause of action. So the fact that you narrowly tailor your groups that you're going to test, and then if they test positive, the fact that you terminate them is not going to allow them to have a cause of action against you in court. So that seemed to be a concern when I was talking to some others. They're like, now they have cards. If they have cards, we can't touch them. Think again. Think again. You can touch them. You just have to make sure that your policy is in place and that you enforce it across the board. Okay, so based upon that, you do have to have a good faith belief that if you're going to punish an employee who has a card, a good faith belief that they've either used or were under the influence at work. And then they won't have a basis to sue you over excluding them from being employed or performing a safety-sensitive position. Okay, so let's talk about, I'm going to quickly go through these. If anybody wants to know more about it, raise a hand and we'll discuss it a little more. But let's talk about how to document it. This is how you're going to make your case. So you're going to often receive complaints. This is how it's going to happen most likely. Someone's going to come in, a coworker, and they're going to say, wow, they smell like a brewery, or they're making terrible decisions, whatever. Start observing them. If they will, put it in writing. If they won't, you document that they came in, who talked to you, was it witnessed by anybody else, gather your documentation, and then your next step would be an observation by a supervisor. I'm not talking about any supervisor here. You all need to set up training for your supervisors with regard to how to determine reasonable suspicion. So these are the people I'm talking about, your trained supervisors. This is pretty easy. It's easier than you think. If you're using Baptist, for instance, they'll come in and do reasonable suspicion training for you. If you have an EAP program in place, they'll do it for free. So call your EAP, call your drug testing facility, and talk to them about reasonable suspicion testing. It is different between DOT and just your regular policy, but only slightly. So you've got to get that done, though. You need to do it at least once a year. Document when you did that training too. Keep it in a file. So if you've got to go to court, you say, I did it every year. It was done on this date. Here's paperwork that was provided. So then you establish a pattern that you've been on top of it. All right, observation by supervisor. Then next you want to have the observation by supervisor. I've got a slide in here, but you're going to have this easy little checklist. You've got to make it easy. People aren't going to comply if it's not easy for them and quick. And you don't want to go 2 hours without sending them for testing when you first notice that they need to be tested. So quickly fill out the form. Everybody's on board with the form. There's an agreement between 2 supervisors and you send them for testing. All right. So if they're in a safety-sensitive position, it's a good idea to remove them from that position. Put them in an area like your office or a conference room somewhere that's removed and they're not performing safety-sensitive tasks while you're still trying to make up your mind if they need to be tested. It's a bad combination. You're asking for trouble if you leave them there. Get your second opinion. Clearly document it, both of you. Talk with HR if you've got an HR personnel. If you've got someone available. If you don't, then as long as 2 of you are okay with it, then you're good to go. Okay, next. Meet with your employee. A lot of people skip this, and I don't really know why. You do need to meet with them. You need to tell them what's going on. You need to tell them you're going to send them to be tested. And maybe this is a little reverse psychology. I've got a 12-year-old, so sometimes I have to use this. But say something along the lines of, not accusatory, we're sending you to be tested because we think you're under the influence, but it works a little better and everybody's a little less disgruntled. If you flip that a little bit and you say, we have reason to believe because of the things that we've marked on our list, like whatever it is that you happen to mark, let them know the basis that you're sending them to be tested, and then say, we're sending you to be tested in order to prove that you haven't violated our policy. I don't know, a little reverse psychology sometimes goes a long way. You kind of diffuse the situation. But and then you're free to say, if you're not under the influence, then this test will confirm that, and everything will be fine. If it won't, please refer to your employment policy, because we will, if it comes back positive, then we'll follow the steps in the policy. Okay, most importantly, arrange transportation. Please do not let them drive themselves. It's a really bad idea. You want to talk about some other different types of lawsuits, that's where we'll be. So arrange transportation to the testing facility and home for the person. So don't let them get into a car. If you just checked 10 reasons why you think that you should send them to be tested, you really shouldn't allow them to drive themselves there or home. All right, so then you send them for testing. You call ahead and let them know that you're sending them because of reasonable suspicion or because of an accident, whatever your basis is, let them know why you're sending them. And then wait for the test results. We wrote it into ours that we don't really want our employee returning to work because we're going to test all of our safety-sensitive employees randomly, but everybody else really falls into two categories, and that's reasonable suspicion and post-accident. That's the only reason we're going to be testing everybody else, which is the vast majority of our employees. We don't really want people coming back to work. If we have reason to send you to be tested, we don't really want you coming back performing duties in that state. So we wrote in that you're not going to return to work, and here's where you have some more choice about how you're going to take that leave. Are you going to take it, you can require them to take it as vacation, sick, I don't know if you have extra days at work, you can require them to take it under your policy with regard to leave, or leave without pay if none of that is available. So you need to write that in so that everybody's on the same page and you know what's going to happen. And you're not giving one person, oh, we'll just do it leave with, well, we'll do it vacation, not leave without pay, and the next person we're going to do it leave without pay. Don't leave the discretion there. Just go ahead and make that one a uniform application. All right, and you need to let them know what's going to happen if they refuse to test. So, I mean, I don't like it when my kid tells me no, but I also don't like it when employees say that they're going to refuse to be tested. Write it into your policy. A refusal for testing is a positive test result and will terminate immediately. It doesn't leave it open for debate. You can have the conversation with them, I'm sorry, but that's not up for debate. So you refuse and you're out. Okay, here's the kind of form I'm talking about. Now, it's kind of hard to read, and I just downloaded this from FAA, but we kind of created our own. I forgot to mention that in this process, and this is important, we actually worked with Carolyn Witherspoon, who'll be here a little later, while we were writing our policy. So I was kind of writing, and we're at the task force, and everybody's got their opinions, and then we would funnel it through Carolyn before we ever finalized it to make sure, because this is a little tricky, and none of us knew exactly how this was going to play out since we don't have a lot of case law. And like our previous speaker was saying, we're kind of all in a gray area, still guessing here. So we wanted to get as many eyes on it as possible. So we worked with her to create our own form for the county. You'll probably want to do the same, but they're all very similar. So it's just this easy checklist. I mean, almost anybody can fill this out, right? Famous last words. You might have some supervisors that weren't there on the day of the training and you didn't record it and they didn't watch it afterwards, but it's a checklist. It's easy. So a 5 minute, they fill it out in 5 minutes, they sign off, and then you have another supervisor that's also had direct observation sign off, and this goes into the file. So you're building your case even before you have your case started. So a good defense is the best defense, right? So a good offense is the best defense. So basically the things that you need on there is the employee information, the time of observation. We got it specific to say the beginning time and the ending time of the observation so we could nail it down even more. The location that it occurred at, your checklist, and then we added in at the bottom, we basically said to the best of our knowledge and belief, and that's not on the FAA form, so you can take it for what it's worth, but we felt it necessary to add in this language, and I quoted it here in case you all wanted to use it on your forms too. But we just want to know that they understand when you're signing off on that, the seriousness of it, and that they take it seriously. So I think having this little statement in front of where you put your name kind of makes you focus in a little bit and make sure that you're not taking some liberties with the boxes that you're checking. Because ultimately, when you end up in court, that's the person that's going to be on the stand. They're going to have to help you in justifying the action that you took. Okay, so I'm going to go quick here. You tell me when I'm done, when I need to stop. but quickly, positive test results. Now what do you do? So if they test positive, what did you all think that if you used, how many people use an MRO, by the way, a medical review officer? So when you do your testing, the medical review officer basically confirms the test results, and then if there is a positive, then they take the time to contact that employee and see if there's a reason why they tested positive. So for instance, are you under any medication? Can you provide a prescription that shows me that you had to take hydrocodone or something along those lines? So if they can provide a valid prescription, then they're going to give you a negative test result, even though they tested positive. This buffer in between you and the drug test is worth the money. It's worth its weight in gold. It removes you from that situation, and then you don't have all this knowledge that you may or may not want to have with regard to any kind of medical condition or disability that you really don't need to know about, and you don't need to have documentation. So that MRO, if you don't have one, put it in your plan. It is worth it. So anyway, I kind of thought originally they might give me a negative test result if it came back and they had a card. But when we really started talking about this, and I called Baptist Health, who's our provider, they go, no, it's still illegal under federal law. We're going to give you a positive, and it's up to you whether you confirm the card or not. So that's how that's going to work. So don't be under the mistaken impression that you are going to be getting a negative if they have a card. And none of us really know exactly what that. I haven't seen a card yet, so I don't know what it's going to look like yet. But they're not going to confirm that for you, so it's going to be different than everything else. So, depending on how you write your policy again, you're going to have to verify the cardholder status. We've written our policy so that we're not going to take that into account. So this may or may not be applicable to you. We've just written it in that we're going to take action, and we've written it so that we either have a basis, a good faith basis based on our policy, and we can go ahead and take action, or you're a safety sensitive member and it's not going to matter. A positive test alone can get you there. So depending on how you write your policy, you may or may not need to confirm that they have a card. So that'll be up to you all too. Okay, try to make it easy. This will wrap up what we've been talking about. When can a drug test alone allow you to act? So I tried to nail it down in each category. If anybody's got questions, ask along the way. But with pre-employment testing, the positive drug test alone can't be the sole basis, except when the employer is bound by, again, federal drug testing requirements, such as DOT. And there's a job classification. Okay, here we go. And there's a job classification listing the person as safety sensitive, or the employee is not a qualifying patient. So if you check the card and the employee is not a qualifying patient, or they don't have a card at all, they just told the MRO, I'm a card carrying member, and then when you go to actually check it, they don't have a card. So either of those things can get you there. You can take action based upon that. So with regard to suspicion, reasonable suspicion, you can, that alone would support a good faith basis. So you've checked your boxes, you've got all your documentation up front, and you can take action on that alone because you already have some things besides a drug test that fall into those other categories of things that are acceptable proof. So you're okay there. With post-accident testing, again, an accident in and of itself, especially if it creates injury or damage, under the way the statute is now written, under Act 593, that alone will allow you to take action. So you can take action on that. With regard to random drug testing, random is the one that everybody ends up in court on. Remember that a drug test alone can't get you there. Again, fall back unless it's required by a federal agency. They've been listed as a safety sensitive position, or they're not a card carrying member. So, and lastly, return to duty and follow up. You have a lot less protection when you fall into this category because you've already messed up. So you're in a different category, and just, you know, your rights and privileges are somewhat hampered when you're in this category anyway. So you can take action, but you do need to have adequate documentation. Okay? All right, so let's talk about how to develop your own policy. You've got to determine what you want. You can't go into it blind, and it's hard to write when you don't know what your outcome what you want for your outcome. Know your outcome, then go back and write it. Who's gonna be tested and why? Is there a drug problem? We've already talked about it in a specific category or group. We're probably not gonna fall into that unless some great studies come out that's talking about within the sheriff's department, there's a high usually in any given number, and they do some great data with lots of empirical data to back up a report, which is most likely not going to happen. So I would rely upon this. But the second one is a catch-all. So are the duties fraught with such risks? And of course, nobody can speak like this except the Supreme Court, so this comes directly from them. Is it fraught with such risks of injury to others that a momentary lapse of attention could have a disastrous consequence? If so, they are a safety-sensitive position. Make sure you document it and put it in your policy, and you'll be fine. Then the next thing that they want you to look at, is there a less intrusive means to accomplish the same purpose? This one's kind of hard and requires some money that usually counties don't have. So if you're not having if you don't have direct supervision of these employees, then I would say there's not a less intrusive means. And if it's financially impossible to hire someone else to oversee a certain category of people, or impractical, detectives, they're in the field, they're working. So are road and bridge crews. You know, rarely do you have somebody standing right beside the road for every single, you're gonna have a job foreman, but they're trying to get a lot done during that time, and they're not gonna have direct supervision of every category. Just know this and know your group very well, and these are easier to defend. Okay, so then you've got to ask yourselves, do you want to accommodate medical marijuana or not? You can write it in so that you'll take into account if your MRO tells you that they are positive, but they say they've got a card, you can write it in so that you'll look at the card and verify the card and then determine action after that. We didn't go that route. If you want to do that, don't use mine as guide, and talk with counsel before you do it. Talk through the consequences of it. We chose to go a very conservative route, at least until we see how this is going to play out. Later on, we might want to make changes, but right now I think conservative is probably a good approach. All right, next, do you have to have a zero tolerance policy? It's called zero tolerance, but you've got to have the ability to discipline your employees like we talked about at the beginning. So as long as you write that in, you're okay. And most of us fall into that category. Check to see if you receive any federal funds. If you get federal funds, you need a zero tolerance policy. You at least need to talk the talk. You've got to know that and write in certain ramifications into your policy, and then you're covered. Have it in writing. That one seems obvious. Train your supervisors. Call in someone other than someone who works for you. Like I said, sometimes your EAP office will do it for free, so there's not a big cost associated with this, but inform them and have them sign an acknowledgement. If they're going to follow just your standard policy and they are not a safety-sensitive employee, just have them sign off on your normal acknowledgement of your personnel policy that says, I understand I can be subject to drug testing. If they're safety-sensitive, have them sign off on something that says, I realize I'm in a safety-sensitive position and that I can be drug tested pursuant to, and then list them out. For me, it's all of the ones that we've been talking about. So make sure that they're aware they're going to be tested under all of them, because later on you're going to have some slacker who didn't read the policy and fell asleep when you did your training, and they're going to come up and go, well, I didn't realize. I knew I was going to be subject to reasonable suspicion and post-accident. Had no idea about random. You want to have a document where they have their name on it. It says that they did know about random, and they stayed at the job anyway. Okay. And again, the last one, just follow up with them and list all the types of testing. All right, be explicit. I can't say it enough. Talk about who's subject to testing, so narrowly tailor your groups. Talk about how it's going to be administered, what lab you're going to use, where to go after hours. You'd be surprised. I get calls on my cell at home saying, where's the after-hour lab? And I was like, I'm not doing that anymore. We'll just write it in. So we wrote it into our policy. It's not like it's going to change in the next year anyway. We're under contract. You can change it at the end of the year. But let them know where they're supposed to go after hours. Sheriff's office, they work 24/7 operation. They aren't there from 8 to 5. Make it convenient for them. They shouldn't have to be seeking out where to send your employees when they're trying to determine if they should send them in the first place. So make it convenient on your people. Get an MRO, for goodness sake. They really are worth it. So make sure you have an MRO. If you're gonna follow the DOT guidelines, it's kind of a basis. Make sure you take split sampling. It'll save you time, and the samples are all taken at one time. Split sampling basically is one large collection, and we're using a urine analysis here because it's kind of the gold standard. If you want to deviate from that, really think about it and make sure that your test has been, that there's some sort of basis for you using that test. So urine test is just a gold standard. A lot of times if you're pulled over on the highway or whatever, they may take a blood sample, and you write in your policy if that's done by law enforcement, there's no need to do a separate test for work, because you're just creating work for yourself and a cost that you don't need. Just use the test that was already done by law enforcement at the scene, but make sure that you're specific with how it's going to be done. We use split sampling, so if they don't agree, if it comes back positive and they want to pay, your employee wants to pay to have it retested, that's fine. With us, we say, okay, you can take the split sample, it has to go to another certified laboratory, and you bear the cost. And if it comes back negative, then it will override the first positive. Chances are that's not going to happen, but leave it out there as an option. Okay, clear and transparent. Talk about what types of tests that you'll do. Make sure that you review all the laws just so you're in compliance with the law. And again, consistent, uniform application. So, lastly, treat it all confidentially. Don't go around talking about so-and-so had a positive drug test, and we know it's positive because the MRO told us that there's a prescription for it, and then you know what that is. You're violating so many rules, I can't even begin to say what they are. Don't do it. Just keep it confidential. Keep it in a file. Only a couple people should even know about it or have access to it. This isn't something that you want across the entire office. It's personal and treated as such. Under DOT, they have all these different rules. I read them and I kind of laughed, and then I go, we're just going to keep them all for 5 years. It's like, keep it 5 years if it's this, keep it 3 years if it's this. If it's a negative, you can keep it this many years. Who's going to remember that? Or pull out the policy each time to make sure they're in compliance. If you're testing under DOT, keep it 5 years. If you're testing just in your office, we're going to keep ours 2 for everybody else. Okay, it's a lot. I'm trying to shove it all in. We did a lot to our policy, y'all. We'd never added we did a workplace violence. We got much more specific with our FMLA policy. We added a technical use policy, which is basically a social media policy. We didn't have one of those. We added that in. So we did a lot to our policy, and it was really much needed. I mean, we hadn't done a social media policy up to this point. It's something that comes up at least on a weekly basis, so we added all of that in. If y'all want to look at it, feel free. It's online. It's under Pulaski County. If you go to HR and then personnel policy, you can pull it up and read all of it. Or contact me. I'm happy to provide it to anyone. So I think that wraps it up. If anybody's got questions, I'm happy to answer, or I'll be around afterwards if you want to come up and ask me a question.
Everybody's kind of talking about this because it's a new thing. Nobody quite knows what to expect, and we're here today to tell you all what's coming. Well, not quite, okay? So when Brandy asked me to speak, what I told her was, I don't know a lot about it, honestly. And so I decided, well, I'm going to go look at what the other states have to say about it, and that's what I'll present on. And so I did that, and I'm not sure I know any more now, okay? But I'm going to share with you what I found out and kind of talk to you about the broad strokes that I think will inform this discussion, hopefully by giving you a few points of data, as it were. We can kind of start to see what the picture might look like down the road. We like to say in our office that 1 point is just a point. 2 points makes a line. 3 points makes a trend. And so when you start putting enough data points together, you can start to see where things are headed. So the big issue, it seems to me, with respect to medical marijuana is the fact that it's legal in Arkansas. And by legal, I mean you won't be charged with a crime if you do it exactly the way the new Arkansas statute lays it out. If you create it, sell it, or use it as the statute applies. But if you ask the U.S. Attorney or the Attorney General of the United States, they'll say, no, it's illegal. That's because federal law still says that marijuana is a controlled substance and it's illegal to possess or use marijuana. Okay? And so the big elephant in the room of all these discussions is, how's that going to play out? And the answer is, so far, it's been of negligible impact. That's because the last administration made a conscious choice, essentially, not to get involved. Where those states said, for the most part, and we'll talk about some of the instances where that's really not the case, but for the most part, they've had kind of a hands-off approach. And so the question has been, what about this new administration? Well, it's mostly been the same. But there's still that open question of where they're going to come from. So I'm going to start off, as I do in essentially every presentation I give, with the Constitution, okay? And a principle that we call federalism. Federalism is the principle of government that we have here in America. So we came from a system of kings in England, and even though we abandoned that system, we've still got a lot of the vestiges. Okay, eminent domain is a good example of that. So for you county judges here that deploy eminent domain, and you can take property to build a road. Eminent is a kingly right. You know, you'll hear in the old King TV shows, a king addresses your eminence. The eminent is the king, and eminent domain is the doctrine that says all land is the king's land, and the king can take it anytime he chooses to. Now in America, we've modified that to say, but only when he provides fair market value. Okay. So essentially, in American government, there are two kings. We're a dual sovereignty nation. One is the federal government, the United States as a whole. The other is the individual state. In this case, it's the state of Arkansas. And so the interplay between those two powers, those two kings, those two sovereigns, informs a lot of the way the law gets enforced. And so we start with the Supremacy Clause of the United States Constitution. We talk a lot about the first 10 amendments, and rightly so, the Bill of Rights. A lot of times we don't talk about the actual document of the Constitution. But in the document of the Constitution, in Article 6, the Constitution says that the federal Constitution, the laws of the United States, the federal laws, are the supreme law of the land. Well, what does that mean in practice? Well, if you look at the federal Constitution, and I've got the First Amendment printed out there as an example, so many people think, kind of in layman's terms, that they have these rights that are guaranteed by the Constitution as absolute rights. I can say whatever I want, anywhere I want, anytime. And anytime you hear about in media there being consequences on somebody for speaking, somebody always says, well, don't they have the right to free speech? Well, yes. Well, what that means is they have a right as against government interference. Okay? That's why if you've been sued as a county official, most likely you've been sued under the Constitution, because in that context you are the government. So the First Amendment doesn't say you have the right of free speech. It says Congress shall make no law abridging the right of free speech or reducing the right of free speech. Congress won't interfere. So one of the questions, particularly in the first 100 years or so of our republic, was, doesn't Congress mean Congress? And the answer essentially was yes, that the federal Constitution only protected you from federal government interference with your rights. Okay? The only thing that would protect you from interference with constitutional rights by the state government would be the state constitution. Well, that changes right after the Civil War with the passage of the 14th Amendment, which I've also got reproduced here. And it says right in the middle of it, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Shortly after that, some cases started coming to the Supreme Court that enunciated a doctrine called selective incorporation. Selective incorporation basically says that the federal rights are incorporated into state law. By saying that the state can't enforce laws which abridge the rights under the federal Constitution, the courts, in particular the U.S. Supreme Court, said, well, by saying that in the 14th Amendment, they've incorporated federal rights for most of them. That's why the word selective. At this point in history, it's almost all of them. And some scholars would say it's all of them. But that it incorporates those rights. And so now those federal rights are applicable to the states. In other words, the state can't interfere with those rights, even though they're the rights guaranteed by the federal Constitution. That becomes really important in a lot of ways. We've seen a lot of changes because of that. One is the rise of the judicial branch. The judicial branch, in particular the U.S. Supreme Court, has taken on a seemingly ever-increasing role in American society and American government. It's also tended to create more uniformity nationwide in the laws, because no state can enact a law that violates the federal Constitution, or at least most provisions of the federal Constitution. The state laws tend to kind of even out, except in areas where states have traditionally had control. But we've even seen that, the recent same-sex marriage opinion by the U.S. Supreme Court, even some of those areas being taken over by the federal judiciary. And so we've seen uniformity. Medical marijuana presents a different dilemma that maybe we haven't seen. And it's the dilemma where instead of enforcing a federal right, say the right of privacy, states can't pass laws banning the practice of abortion, okay? Because it violates the federal right of privacy. That's essentially the Supreme Court's holdings in Roe versus Wade and a number of other cases since then. Instead of enforcing uniformity, because we're going to make all the state laws fall in line with this federal principle, the federal principle is different from what all the states are doing. Okay? And so the question arises, is the federal government going to make us all fall in line at some point? And are we going to get whiplash when that happens? Okay? And so some of these cases, what I've done is I've just kind of done the research and searched for these cases to see in various respects how the courts are coming down. Now, let me give you a couple of caveats before we kind of dig into the specific examples that hopefully will give a little bit more clarity, or at least a glimpse into what we're looking at, what kind of issues the courts are going to be dealing with. One is, this is kind of scattershot. There's not really rhyme or reason to where the courts have come down on some of these. That's principally a function of the court's Article 3 duties. Courts don't just give opinions on whatever they want to give opinions on. They're limited to giving opinions only in genuine cases or controversies. And so you see litigation come up in one particular context, like the Americans with Disabilities Act, for instance, is the first issue we're going to look at. But not in other areas. Well, that's because there's no dispute. Okay, nobody's getting mad about anything over here. And so it's only when somebody gets upset or gets in a dispute that you're going to see litigation arise. And so because of that, and because of the limited time window we've had, you're going to see a limited number of results, and it's going to tend to kind of be all over the place. And so there's not really rhyme or reason on where the courts have come down on particular things. The other caveat I would give is a geographical one. Most of the states that have adopted medical marijuana are western states. California, Colorado, Nevada, Oregon. The way the federal judiciary is set up, is in circuits. There are 13 circuits across the country. We're in the 8th circuit. The 8th circuit runs all the way up to Minnesota and back down to Arkansas. Nebraska, Iowa, I think there's 8 states in the 8th circuit. All these western states, or many of them, are in the 9th circuit, whose Court of Appeal meets in San Francisco. Now, you might imagine that western judges that meet in San Francisco have different sensibilities than Midwestern judges that meet in St. Louis. And I'll just tell you, based on my experience, you'd be right. Okay? It just is. They view things differently. And so that's another caveat is we're looking at cases decided by courts other than our own. Very little, if any, 8th Circuit guidance on this, mostly because none of the states in the 8th Circuit have adopted medical marijuana yet. Okay? And we're seeing that coming, and so we'll see what they do. So let's start with the ADA, the Americans with Disabilities Act. It's a big area of employment laws for counties and for private employers alike. Okay, the Americans with Disabilities Act protects any qualified individual with a disability. Okay, and so a lot of the cases deal with that opening question. Of course. If you're a qualifying person with a disability, there's all these rights that you get under the ADA. Most notably, probably the right to reasonable accommodation. If you need an ergonomic keyboard to deal with your carpal tunnel syndrome, you're entitled to get that, okay? Unless, generally speaking, unless the employer can show an undue hardship. So if you need the county to build you an entirely new building to accommodate you, that's probably too much fast, okay? I remember the case where the deputy needed a new squad car, but literally couldn't fit between the seat and the steering wheel. And that was a question of undue hardship. So that's where the cases come down. That's where a lot of the litigation comes in, because most of the time on ADA cases, you're not dealing with, is this person disabled? You're dealing with, well, what kind of accommodation are they asking for? Is this really an undue hardship? In medical marijuana cases, you are going to be dealing with the definition. This 9th Circuit case, this is from 2012, the case opinion begins with this quotation that I've got here. The plaintiffs are severely disabled California residents. Okay? Now, the court uses that disabled term in the common parlance. These people have serious medical problems, okay, that render them disabled. But they go on through the case to discuss what that term means in the statute, okay? Well, there's a really important exclusion from that definition in the statute. The term individual with a disability does not include an individual who is currently engaging in the illegal use of drugs. Well, California passed a law that said it's not illegal to use marijuana. This employer had a zero tolerance policy. I like zero tolerance policies too, because my employment experience tells me no good deed goes unpunished. Okay? But this employer had a zero tolerance policy. They did random testing and tested this person, and they came back positive for marijuana. And this person then made an ADA claim and said, I'm being discriminated against on the basis of a disability. Actually, this was more than one person. It's happened to more than one person. And so the question was, is this person a person with a disability? Ultimately, the 9th Circuit, okay, again, the 9th Circuit tends to be on the left, okay? And they said, no. You know, you look at the definition and you read it, and it says if you're currently engaged in the illegal use of drugs, and even though it's legal under California law, it's clearly illegal under federal law, you're out of luck. The ADA isn't even triggered, okay? We don't even get into the analysis of whether they should have provided you a reasonable accommodation, engaged in the interactive process, or all those other things that you normally talk about in the ADA case. We don't even get into that because you are currently engaged in the illegal use of drugs, therefore you are not a qualified person with a disability. Isn't that interesting? I find that really interesting. Okay, section 1983, jails. This is what we do all the time. I've represented many of y'all in this room. I see a lot of familiar faces. And we get a lot of these jail cases. And so the one I pulled here is a Northern District of California case, also from 2012. I love the plaintiff's name in this case, Smiley Harris. I bet he was smiling after all the medical marijuana he'd been using. But he went into jail just for a few days, but he sued him for not letting him use the medical marijuana in jail. The case came down exactly as I would expect it to come down. I'll just be honest with you. I've seen this case 1,000 times, except instead of marijuana, it's hydrocodone or some other narcotic drug, or even non-narcotic drug, Seroquel or something that the inmates like and that they want, and the doctor at our facility says, no, I think ibuprofen will be fine for you. Okay? That happens all the time. Well, this court says, sorry, as an inmate, you don't get your preferred course of treatment. You're entitled to medical care. You're entitled to the standard in the jail cases under Section 1983. Section 1983 is the federal law that allows you to sue for violation of your federal rights. If you hadn't been sued under one of those, just as an explanation. But essentially they say, as long as the doctor is exercising medical discretion and decides some other pain reliever is fine for you, that's good enough for us. It's always the key. It's always what we advise when we talk about medical care in jails. You can't be deliberately indifferent. That's the standard in these cases. You can't know of a serious medical need and disregard it or ignore it. Okay? You got to do something about it. But you don't have to do what they want you to do. Okay? And medical marijuana falls into that category. There's no constitutional right to demand jail officials to provide plaintiff with the medicine of his choosing. And then they just go on after that quotation from another case and say, including medical marijuana. I think it fits neatly into that category. It's just like I say, 1,000 other cases we've seen. All right, let's talk about guns, because this is a really interesting one. And I'll admit, I stole most of this from an article in one of the lawyer magazines. A lawyer at the Rhodes Law Firm wrote a real good article on this. The Federal Gun Control Act of 1968 is codified in Title 18 of the U.S. Code. It shall be unlawful for any person who is an unlawful user, there's that word again, unlawful user, of or addicted to any controlled substance. Now, notice it says, as that term is defined in Section 101 of the Controlled Substances Act. In other words, as that term is defined in federal law. Marijuana is a controlled substance under the federal law, okay? So if you're using or addicted to marijuana, it is illegal for you, and if you go down to this subpart G3, to possess any firearm or ammunition, okay? That's pretty robust language. It's illegal for you to possess a gun if you're using marijuana under federal law, okay? So then we look at Wilson versus Lynch, case from just last year, again, 9th Circuit, San Francisco. You kind of got an idea where they would want to come down on a gun control law. You just do. And so on this one, a person that had a registry card to use medical marijuana in California went to buy a gun. The gun dealer knew the person and knew that they had a registry card and wouldn't sell the gun under the federal law. Okay. This is a real interesting opinion to me, because if you go down to that second paragraph, it says, Title 18 of the U.S. Code, Section 922D3, and then it cites a federal regulation relating to that subsection of the code. And the open letter is a letter that has gone out from the Bureau of Alcohol, Tobacco, Firearms, and I think they've got explosives in their acronym now, but that's gone out to gun dealers nationwide. It says don't sell guns to medical marijuana registries. But the opinion here says, bar only the sale of guns. Well, that's right. This D3 bars the sale of guns. The opinion doesn't address G3, which bars the possession of guns. In fact, the opinion says D3 and these other, the regulation and the open letter from the ATF, don't bar possession. Well, that's true, but another subsection of the Act does bar possession. The opinion just didn't deal with it. The opinion also said it didn't severely, you go on down here, didn't severely burden her core right to defend herself under the Second Amendment. This is the court's Second Amendment now, so she made some claims under First Amendment and some other authorities. But under the Second Amendment said, doesn't severely burden her right to defend herself because she could just turn in her registry card and go buy a gun tomorrow. Okay? It's an interesting opinion. I think other courts would come down differently on this, because I do think that Act says you can't possess a gun if you're using marijuana or you're addicted to any of those controlled substances that are listed. So while this case is instructive, it tells us at least how one of the 13 federal circuits would rule on this. Gosh, it looks to me like they dodged the issue. And so I'm not sure how instructive it is. I think it's an open question. I think it's an interesting question. A real Hobson's choice for some, I guess. Which do you want, your gun or your marijuana? I think it's an interesting one. Lawyer ethics. I know we're getting some CLE credit for this. I've seen several lawyers here today. And there is such a thing as lawyer ethics, okay? That's a real thing. I know it's like jumbo shrimp, right? Doesn't seem to go together. But we do have ethical rules, and the Supreme Court watches over us. And if we see Stark Ligon's name, who is kind of the czar of that program, lawyers kind of get all tensed up about that, and probably rightly so. But Rule 1.2D of the lawyer ethical rule says a lawyer shall not counsel a client to engage or assist a client in conduct the lawyer knows is criminal or fraudulent. But the lawyer may discuss the legal consequences of any proposed course of action. So what about a lawyer who's hired by somebody who wants to set up one of these dispensaries? Is he counseling a client to engage in a crime? That's fine, though. Sure looks like it. At least under federal law, but it's certainly not under state law. It's expressly authorized under state law. So would it be okay to discuss the legal consequences of those proposed courses of action? Certainly would be okay to do that. When do you get over into counseling and engagement? It's an interesting question. The Bar Association has proposed a comment to that rule to the Supreme Court. They have not yet adopted that comment, but it would clarify that a little bit and basically say, make sure you get everything in writing, that you're telling them about all these laws and you're telling them in writing, so that if the federal government ever decides to swoop down on them, at least you can say, hey, remember that letter I sent you? Okay. Different states, I also looked at this, different states' ethics committees have viewed this differently. So one state, I looked at Arizona and Ohio, one of the two, I don't remember which, came down and said, no, this looks like counseling somebody to engage in a crime. The other one said, nah. So, who knows, okay? Be very careful is what I would say. Tax implications, federal tax law allows for the deduction of, this wouldn't necessarily apply to any of the counties, but I just kind of found it interesting. Ordinary expenses carrying on the trade or business are normally deductible, but not if you're trafficking in controlled substances. Now, I found that really interesting because you're still supposed to pay your taxes, you're still supposed to report it all, but if you're trafficking in controlled substances, don't take those deductions, okay? That's how they got Capone, right? They're serious about you paying the taxes, even if you're committing a crime making income. But this particular plan tried to say, well, we're also giving counseling when they come in to get their marijuana. And the court said, no, we don't think so. It doesn't look like it does. It looks like you're solely a controlled substances trafficker, and therefore we're not going to let you deduct that. Unemployment compensation, another employment law thing, doesn't really implicate federalism the way some of these others have, because these are state programs. And this is a Colorado program, which is a little bit different. But once again, you had somebody, again, with a zero tolerance policy, was terminated when they tested positive for marijuana, and then applied for unemployment benefits. And the Colorado Appeals Court said, no, you're not entitled to unemployment benefits because you violated the policy of the county, engaged in misconduct by violating the county's policy. He tried to say, well, it's legal, it's not illegal. They said, well, that's a matter of criminal law. You're not going to be exposed to criminal liability, but it doesn't insulate you from being denied unemployment compensation, so they denied his claim there. I don't know how that would come down in Arkansas. I think that's an interesting question, whether it constitutes misconduct in the unemployment parlance to violate the policy in a way that is clearly legal under state law, even if maybe it's illegal under some other law. All right, so what questions do y'all have? I know you've been discussing some of these hot button issues. What questions?
I have one.
Yeah.
You addressed the cardholder's right to, where he's not able to possess a gun or ammunition, but you did not address the caregiver's right to possess a gun or ammunition. How would that fall?
I don't think that the caregiver is I don't have the statute in front of me, but I don't believe caregivers are discussed in that act.
But they're legally able to possess marijuana.
Well, it's not the possession of marijuana that triggers it's not the possession of marijuana that triggers the Federal Gun Control Act. It's the use or addiction to the controlled substance that triggers that. So I don't think it would. I think the caregiver would be okay. So
don't have a card.
you run into one of the, well, it runs into one of the other issues that comes up. It's not really been litigated because, again, litigation requires a genuine dispute that people actually want to raise. So one of the issues that they're seeing in Colorado and elsewhere is now the banks will take the money. Federal banking regulations prohibit the deposit of certain types of ill-gotten gains of a sort, and so none of the federally chartered banks will take the money, and so these businesses end up dealing almost entirely in cash. They pay their employees in cash. They have these large cash hoards, and so they have to hire all this private security and so on and so forth. It's creating all sorts of problems. And so you run into the problem of, what about the caregiver who's making house calls with an armed posse, you know? How much of that are we gonna, then you get into, well, do we have an open carry law in Arkansas, and some of those other questions that we like to fumble around with. But there are some real issues there. But no, I think under the federal law, I think that the caregiver would be allowed to, as long as the caregiver wasn't sampling merchandise. What else?
I just make a comment on that. So
Yeah.
The federal gun control act may not, but it's a federal crime to possess a firearm in furtherance of a drug crime. You get an extra 5 years consecutive to any other offense just for the possession. And I think there's a lot of gray area in terms of if you're just a caregiver and you're not using or possessing a firearm. Is that furtherance of drug crime? I don't know.
Well, that becomes the question of, is the federal government going to prosecute you for it? If the federal government prosecuted you for the possession, yeah, I think it could be. I think you're right on that.
So it's my understanding that Jeff Sessions has formed a task force to look at the link between marijuana use and criminal activity. And so I think there's a potential that we might see a change in the stance of the administration with regard to state activity versus federal law. Any clues as to how that might come out? But I think they're supposed to come out with a report sometime fairly soon.
Well, I know folks disagree to a great extent about this administration. But one thing I think can be said about this administration with near unanimity is nobody really knows what's coming next.
Right.
So I think that it's hard to say on that.
I agree.
And I think that if they do, I think the groundswell would create a notice period. So I think there would be a period to conform our conduct. I mean, you know, the Constitution prohibits ex post facto laws. You can't kind of come up with a law on the back end. Now, this wouldn't be that situation because there's a law on the front end telling you it's illegal under federal law to possess this stuff. But I think, to me, principles of fundamental fairness say you got to let people know if there's a law you haven't been enforcing in 10 years that, oh, we're going to start enforcing that. It seems to me you got to let people know about that. And the way the courts have kind of responded to the whole travel ban thing makes me think that they would respond that way. At least allow for some kind of notice period.
I don't know if there's any preordained outcome here, but I think his comment was marijuana is only slightly less awful than opioids. So that sort of tends to indicate his...
Well, particularly when we're in the midst of this opioid overdose crisis. Yeah.
I've got a group of guys who think that next week they're going to be rolling joints and breaking. How will medical marijuana affect CDL licenses? Will the card holders have to give up a CDL?
I think I might be able to answer some of that. Under federal law, it's still illegal. There is no grace for it under a CDL. So according to the DOT regs, you've got to have a policy that somehow engages in discipline for that employee, up to and including termination. So the way we've written ours, we're just going to terminate.
But do they lose their CDL?
Oh, good question.
They get their marijuana card
Right.
and forfeit their CDL.
I'm not sure I've ever looked at that in the regs because I haven't had that scenario come up myself, but I'm certain that you have to go through SAP training and then test back through return to duty and follow-up testing, and maybe if you test clean for some, my gut's telling me if you test clean for so many times, you might be able to get it back, but it's going to give you a different.
In the tax law, there's a thing called a taxable event, which says you don't have to pay taxes every year on your investments. You just pay when you sell the investment and realize the gain. I think the answer to that question would probably be whenever the federal government finds out you've got a card, they're going to yank your CDL. There'd have to be an event.
There's a database. I mean, for you all that have to do this, you know that there's a database. So when they do testing, the results are put into the database. So even prospective employers can look back and see that you've had a history. So they go back 5 years according to DOT regs. So it's pretty serious.
But as an employer who has CDL drivers,
Yes.
I'm not allowed to know they have a card, is that correct? There was a comment made earlier, or maybe I'm not allowed to know why they have a card.
It's confidential medical information. It's exempt from FOI, as I understand it, except for confirmation to law enforcement.
Do they have to present their card as an employee to the employer? When they get their card, they come up and say, look, I've got a card,
I don't think that you're
I'm
going
driving
to,
stone.
I mean, I might be speaking out of turn here. I don't think you're going to see CDL drivers with cards because it's still illegal under federal law. So even if you're doing it in your downtime, if you test hot, because it stays in your system, depends on how frequent a user you are, it can stay in your system anywhere from a day to 60 days if you're a frequent user. So most people aren't going to be out of work for 60 days before they come back in and hit a random at some point. When they test positive, they're going to be out and the card's going to be gone. I'm talking about their CDL is going to be gone. So So I don't think we're gonna have that scenario. Might be wrong about that, but we'll see how it plays out.
Yeah.
If Jeff Sessions decides that he is going to enforce federal law, does that stop all of this? And where do we go?
Yeah. He asked if the federal government decides they're gonna start enforcing the federal law that prohibits possession of marijuana as one of the list of controlled substances in their list. Would that end all of this? I think mostly because I think assuming the local federal officials were willing to follow through on that, the fear of prosecution would be too great for people to carry on, at least openly. The same way it is now.
Everything you said is true, and I have said if the U.S. Attorney or the Attorney General says stop, we shut this puppy down in a moment. That's half the answer. There are three other things that gets a little deeper than y'all really wanted. There's two things called the COLE, C-O-L-E memos. Are there three COLE memos?
Three COLE memos plus FinCEN.
Plus the FinCEN, and an appropriation in Congress which tells the Justice Department you may not use federal money to prosecute the possession and use of marijuana if it is regulated under state law. So Attorney General Sessions, God love him, doesn't have any money to investigate or prosecute. If he does, he's actually violating the federal laws that say what you can spend money on and what you can't. So he can go to jail with us. That's a bad thought for my, if it was me going. So it starts getting kind of nebulous there. Right now, that's how Congress has sort of made it illegal. And then two, when you read the COLE memos, the Attorney General of the United States has the authority to grant immunity from prosecution. That's part of his duties. And when you read the COLE memos, a very good interpretation is that those that are complying with state law are immune from prosecution. Okay? So that's the legalities that's kind of floating on the 26 plus states that are now legalized this, plus another 17 that are about to. And so we have an Arkansas Attorney General opinion on that, because I asked him 2 months before the election, wrote a letter, hey, if this thing passes, do we have to do it? And she came back, she said, well, after the election, I'll answer it. And she did. She said, yep, you got to do it. So it starts getting real complicated, but that's the legalities of it.
I think that's right on.
And I was just a little deeper in the weeds than you were, and didn't want to be.
All right, well, my time's up, so thank y'all. Appreciate you.
There are a lot of states that have legalized medical marijuana and recreational marijuana. So we're just one of the first in the South, but it's good to be first in something. So here's our map as of today. So as you can see, we're there in blue, right by Louisiana for once, definitely ahead of Mississippi, but also ahead of Texas and a lot of other states. And we're one of the few states that has a law that contains protection for employment positions. So I came from the public employment sector. I was in the city attorney's office for a number of years before I went to private practice. I only do defense work for governmental entities and also private employers and nonprofits. So I'm on the good side. So Colorado's done a lot of research, and they're making boatloads of money in Colorado. They just don't know where to put it because of the banking situation, but that's going to be worked out because I think they're going to shuffle their money over the border to Canada, and Canada's going to make a lot of money off that deposit. So the average patient is 42 to 43 years old and a male. So this is an interesting statistic. The most common treatment in Colorado is severe pain and muscle spasms. So you all know about muscle spasms. I've got a herniated disc. I'm looking forward to seeing what my doctor's going to do. In fact, when I was coming over here today, one of the secretaries in my office said, "You're walking kind of stiff." And I said, "Oh, got back problems." I hear it coming. So, lots and lots of tests are being done, and in general, positivity, of course, has increased. No surprise there. But we've got the use of opioids, which hopefully are going to decrease. So let's talk about medical marijuana. We're not talking about smoking. We're talking about something else other than smoking. So we're going to go over some hypotheticals. So this is when you get your bonus points to earn your pills for later and fill up that little bottle. So, I don't even know what a card's going to look like, but we think the card's going to look like this. There's going to be a cute picture of whoever you are on the card, and it's going to have, you know, your date of birth, your address, and then you're going to be paying a lot of money for your card. So, Joan. Joan is an employee in the assessor's office. Are there any folks from the assessor's office here today? Raise your hand if you are. No, because we can talk about them. So Joan provides you with her registration identification card. You all know that's what she needs. She sends it via email. Is that bad? Yes or no? Yes. Yeah, because you don't put stuff on email. Medical stuff too, because it could be considered medical. So the question is this medical information, and do you have to keep it separate from the personnel file? Raise your hand if you think you do have to keep it separate from the personnel file. Oh, God. 371-9999 is my phone number, and I'm going to help you for a small fee. Okay, so the identification card doesn't include the employee's medical information, but it should be kept separate because it's going to indicate that the employee has a medical condition or a disability. So we all know, I think you talked about the ADA today, did you? ADA, Americans with Disabilities Act. We all know that the card has this medical information on it or some sort of information about a disability, and once you have medical, you keep it separate. It's better to keep it separate from the personnel file because of ADA requirements. So those of you who did not raise your hand, take 2 steps backwards, and the rest of you guys are earning your pills. Keep it confidential is another reason to keep it separate in the medical file, because you don't want other people coming through those personnel files trying to find out stuff on their coworkers. Now, next question. James works with Joan. James is a supervisor. Can he be told that she has this registration card? For those who say answer yes, raise your hand please. Oh no, y'all. Okay, supervisors sometimes can be told because they're on a need-to-know basis. Just like if somebody in your office has epilepsy or a heart condition or high blood pressure, sometimes supervisors need to know about those medical conditions in case something happens at work. Now what about Joan's coworkers? Raise your hand if you think a coworker should know that Joan has a registration card. Oop, 100% right. Nobody should tell coworkers anything. Okay, what if Joan, instead of giving you the registration card, gives you a written certification from her treating physician, who's a chiropractor or a podiatrist? Can you put that in the personnel file? 100% right, you cannot. A doctor will give a qualifying patient a written certification, and that's going to have medical information on it, so it needs to be separate. The person that's Joan in this case is going to take that information to the health department to get the registration card, which they'll carry in their wallet with their driver's license and their American Express card. Okay, please remember that under the Medical Marijuana Act, that certification is not a prescription or a medical record, but it does have information on it, so please keep it separate in the medical file, always. And don't tell people about it, just like you wouldn't tell somebody in your office about somebody's medical condition. Okay, your accounting manager comes to you. Any people in here from accounting? Okay, your accounting manager comes to you and says, okay, I've been reading about medical marijuana in the newspaper. Do I need to look at our policies and review them at this point? Raise your hand if you think that that question needs to be answered yes. Some people are, okay, it should always be yes. Of course, all your policies need to be reviewed because who knows what policies might need to be changed in light of medical marijuana. For instance, you don't want somebody bringing it into the workplace. That's a no-no. On the other hand, you've got these disability provisions that are going to be affected. You're going to have to make reasonable accommodations. Have you all talked about that? So there's lots of policies that are going to be impacted. Again, my email address for help on that, cspoon@cgwg.com. And your substance abuse policy is the first policy that needs to be looked at. It needs to talk about what's going to happen, what kind of accommodation policies are you going to have. That's going to be one of the most important policies for you to change in your handbook. And did you all discover or disclose or talk about the pre-duty disclosure forms yet? So one of the things that you can do is consider adding a pre-duty disclosure requirement for safety-sensitive employees, like those employees in the back of the room when you all discussed the CDL, where the person has to self-disclose if they're taking something that might impact their ability to safely perform their function. So that's one of the things you need to do, and then you need to modify your definition under the influence to comply with the Arkansas Medical Marijuana Act. If you don't have a substance abuse policy, please consider adopting one. Now, should your drug and alcohol policies be in writing? Yes. Yes. And then you're going to set forth what the conditions are for testing in your office and what the conditions are not only for testing, but also what happens if the person tests positive. So you want to have something in writing. Okay, Jim. Anybody in here from the county clerk's office? All right, finally hit on one. Okay, Jim went to the movie last night and he was arrested for using marijuana at the movie theater. Okay, first of all, should we qualify him as a 10 on stupidity? Yes. I don't know what movie he was seeing, he probably didn't care. But he didn't report that arrest. And he didn't tell his supervisor, and you learned about it from another employee. So can you still prohibit the use of off-duty illegal drugs under the Arkansas Medical Marijuana Act? Raise your hand if you think you can. Yes. Yes. Is it a problem? Is it a problem that Jim, who is a supervisor, by the way, is using an illegal drug, probably, I should have put he was smoking it, smoking marijuana at the movie theater, just besides being stupid? Okay, that's true. It depends on what your policy says. First of all, he's not a qualifying patient if he's whipping some weed at the movie theater, so you can terminate him because he's not protected, number one. Number two, even if he's a qualifying patient, if he's in a safety-sensitive position, you can still terminate him. Number three, if he's a qualified patient in a non-safety-sensitive position, you can still terminate him. It's okay to say the off-duty use of illegal drugs may be prohibited. What your policy needs to do is state that, and you probably have in your substance abuse policy that if you're arrested, that you've got to report that to someone. So that guy's toast. Okay, Susan and Perry. Susan and Perry are in the county parking lot in separate vehicles. And during work hours, they literally run into each other in their cars. You tell both of them they must be drug tested because, you know, significant front-end damage. They both refuse. What do you do? Oh, okay. Sheriff Lucas says you cut off their neck. Good. Good response. I like that. What can you do legally? What would you do? Bingo. If you have a post-accident testing policy, which you will have, you're going to explain the consequences and tell them, look, if they refuse, they can be terminated. Because there's cause, reasonable cause for them to be drug tested and they refuse to consent. Now, would your answer be different if Perry was not in a county vehicle, but Susan was? No, would not be different. You still tell them they have to be tested, doesn't matter which car they're in. Now, here's a suggestion on what to include in your drug and alcohol policy. Reasonable suspicion testing, some post-accident testing, because we still have a little problem with OSHA on the post-accident testing. Pre-employment testing post-offer. What happens if you refuse? What the failure levels are, and then a discussion about what kind of panels you're going to use, because if you've got CDL, you're going to use a 10 panel and 5 panels maybe for others, and you're going to put in there who you're going to test, because you may not want to test everyone in the office, or you may not want to test all of your applicants. Okay, question. I haven't updated my substance abuse policy. Can I still drug test under the old policy, say in November? Raise your hand if you think you can still drug test under your old policy in November of this year. Yes, the answer is yes, you can. At least you've got something. You can still test as long as it complies with the state law or the federal law. Okay, now, even if you have your old test and you're not changing your test yet for some reason, you still need to be concerned about the marijuana employment protection for all of qualifying patients. So be concerned about that even if you haven't updated your test yet. Okay, some of you have federal contracts that, and I'm not sure who's in here that if you're federally funded, so just pretend like one of you is. And you're getting maybe know about an employee who's taking marijuana because you've got a federal contract. Should you know about that person under the federal contract? Yes, I see people nodding your head. You get just 2 steps up and your bottle gets filled. Some federal contractors and federal grantees are required to comply with the Federal Drug-Free Workplace Act. And I'm sure y'all have talked about that today. So you've got to make at least a good faith effort to maintain a drug-free environment, which includes no medical marijuana. Okay, got any accountants in here? Elizabeth, an accountant, is using medical marijuana for the pain associated with her cancer treatment. She tests positive on a drug test. What do you do? She's an accountant, she has cancer, she's test positive. What do you do? One suggestion, you get your bottle filled if you make a suggestion. No cutting of the throats. Okay. What about Flo? Flo figures since she was using medical marijuana during chemo, she might as well go hippie retro. Maybe that's what Joan looks like when she's at work. First of all, you need to make sure that you're complying with the Arkansas Medical Marijuana Act. So before you take any action against Elizabeth, the accountant, you need to know if she's a qualifying patient and what kind of job she's in. So that means you should have job descriptions. Does everybody in here have a job description? Do your job descriptions address whether the person's in a safety-sensitive position under the Arkansas Medical Marijuana Act? Because they need to. They need to all be reviewed, and there needs to be some decision as to whether the person's in a safety-sensitive position. Because if you are, you can only take action on because of the positive test if they're in a safety-sensitive position. And remember that Joan has cancer, so she's going to be a very sympathetic plaintiff. Now, what if Joan was a short-term employee? Does that make any difference in your analysis? No, it does not. It doesn't matter whether she's short-term, long-term, temporary, or, quote, regular. Barry's an applicant for a clerical position. He comes in and he interviews with you, and he does not tell you that he is carrying a registration identification card. But Barry's aunt lives behind you, and over the fence, Barry's aunt has told you all about Barry and about Barry's health issues. So you knew about that before Barry comes in for an interview. So should you ask Barry about his registration identification card since you know about it from the aunt? Ooh, 100%, you're correct. No, do not. Why? Because that's getting into medical issues. First of all, the Arkansas Medical Marijuana Act does not prohibit you from asking about that information, but just as we would not advise you to ask an employee about whether they have cancer or they're an alcoholic or a recovering drug addict or have high blood pressure, you're not going to ask them about their use of medical marijuana and the ID card, because that leads then to medical questions. And when it leads to medical questions, you can be in violation of the ADA or the Arkansas Civil Rights Act. And that, in fact, leads you to whether somebody has an actual disability or a perceived disability. So I want to take a quick break from my slides today and say that just about 5 minutes before I left the office, I was notified that the Massachusetts Supreme Court came down with a decision on the use of medical marijuana. So has anybody talked about that yet? Okay. I haven't read the whole thing because it's 20-something pages long, but it's the first case in the nation to deal with the use of medical marijuana. So because it touches on this issue, I want to go over it for a minute because it's an important case, and because once a case like this comes down, then other courts are soon to follow. So it's Barbuto versus Advantage Sales and Marketing. The issue was whether this woman was a qualified patient who had been terminated because she tested positive for marijuana, and whether she had a civil remedy against her employer. And the Massachusetts Supreme Court said that the plaintiff could seek a remedy based on handicap discrimination under the Massachusetts law. So that's the same thing that the accountant would seek, that Barry would seek relief from, would be the same thing. In this case, Barbuto had Crohn's disease. She used marijuana for medicinal purposes, and she said she didn't use it daily, wouldn't consume it before she came to work or at work. This is what she told her employer while she's interviewing. So, Barry didn't say anything. This woman gave information. And the supervisor who interviewed her said, oh, no problem. The lawful use of medical marijuana would not be an issue with the company. But the human resource representative terminated her after her first day at work, after the interview. She came in, she got her uniform, she got a supermarket location, she was going to promote some products in the supermarket. She didn't report to work in an intoxicated state, so all they knew was what Barry may or may not have said in the workplace. HR terminated her and said, we don't care if you use marijuana to treat your medical condition. We follow federal law, not state law. So Massachusetts did not think fondly of Mr. or Miss Villarez. I think she was sued personally too. That's another reason why you don't want to do what this person did. And eventually, she being the Barbuto, the plaintiff, filed a lawsuit under the Medical Marijuana Act in Massachusetts. Because I didn't have time to read it, I can't tell you if it's similar to ours, but they did allow the use of medical marijuana in Massachusetts. And she was able to assert that she had a qualifying condition, Crohn's disease, and so the Massachusetts Supreme Court said, well, you can pursue a cause of action under our medical marijuana law. So assuming that Arkansas follows that, Barry would have, if he was refused to be hired, or if he was asked illegal questions, then Barry would have a cause of action under the Arkansas Medical Marijuana Act, if they follow Massachusetts. And we don't know, you know from being here all day, we don't know what the courts are going to do under any of these cases. So the best thing would be for the courts to argue and apply Massachusetts law if it's similar to ours. So we know that the Arkansas Civil Rights Act, which I'm sure you've discussed today, and the Americans with Disabilities Act prohibits discrimination on the basis of some type of disability. And then there are employment protections for card holders under the Arkansas Medical Marijuana Act. So Barry's going to have protection under not one, but perhaps 3 laws. He's going to assert, you refused to hire me because you knew I was using medical marijuana for a medical condition. And his aunt's going to be Exhibit 1 because she's already told you, the supervisor, that Barry's been using medical marijuana. He's going to be a sympathetic figure, probably has a disabling brain tumor, so it just makes it even worse. So you need to be very concerned about that. Okay, next scenario, road department. Any road department folks in here? Yep, good. Okay. So Jerry, a road department employee, is a qualifying patient, but he's not told you what his underlying medical condition is. You just know that he's a qualifying patient. The question is, are you allowed to ask him for the information as to his underlying condition? I see a lot of head shaking no. That's correct. For the reasons stated on the previous slide, you cannot ask employees what their underlying medical condition is. Just as if the person came in and said, I'm on such and such drug, you can't say, well, why are you taking that drug? You can't ask those questions. We would not advise an employer to ask about it or to ask about the medical marijuana use. Instead, again, think about using the pre-duty disclosure opportunities that are allowed under the Act. And once you do that, then you can have that sent to your licensed medical review officer who can tell you if this person can safely perform the essential job duties of his position. And you can also send that job description that you've done to the MRO. All right, backhoe operators. And who in here supervises backhoe operators? I think they have the most fun jobs. So Sam's a backhoe operator. Your policy requires pre-duty disclosures if they're taking some kind of impairing drug, whether it's legal or illegal or over-the-counter or prescription. Do you discuss that with Sam even if you don't have a job description? Or, question, Sam comes in and asks me what to do about coming back to work. How do I respond if I don't have a job description? So first question, Sam, the backhoe operator, you don't have a job description. Do you discuss with him the pre-duty disclosures or return to work information? Yes, if you have a policy. Because you have identified that a backhoe operator is indeed in a safety-sensitive position. Why? Because he operates dangerous equipment. So you want to have that job description to identify what you need as far as safety-sensitive positions. You want to adopt a pre-duty disclosure policy because that would at least allow you to provide information to the medical review officer along with the job description. So for your backhoe operators, you definitely want to have job descriptions. Okay, Sam reports to work after an accident. I ask him to disclose the drug or medical condition to comply with our drug policies, but he refused. He won't tell you what he's taken. So what are my next steps? First, you can't require somebody to disclose the drug or medical condition, but just like you can for any other condition, you can say, okay, I'm going to get a fitness for duty return to work exam done. I'm going to get a physician's recommendation as to whether he can perform the essential functions of the position safely, and I'm going to send the doctor the job description. Does that make sense? Okay. So once Sam has disclosed that he has a herniated disc, can you send him for a fitness for duty evaluation? He's taken medical marijuana for it. What can you do? Yes, as long as you've reserved that right in your policy. You should always send a copy of the job description to the doctor and always ask the simple question, can Sam perform the essential functions of the position with or without a reasonable accommodation? Here's the job description. What does he need to tell us to do? Okay, Mary is operating a forklift. She's at a citizen's location. She happens to be using her marijuana at work. She has an accident, the water line, she breaks the water line. Mary's not hurt, but the water line's broken. So the citizen is not happy. What are the ramifications for liability for the county if Mary's on marijuana at work, has an accident, and busts the water line? Tort immunity. Trick question. You know, you may have some insurance that covers it, but if you don't, just because Mary was on the forklift doesn't mean you're automatically going to be liable. But, again, Mary's position should be designated as safety sensitive. Somebody should have been observing Mary during work or before work to see if she's a little bit high. What was her supervisor doing? You're going to want to do an investigation, right? You're going to bring the supervisor in and say, look, did you assign Mary to work on the backhoe this morning? Did you notice anything funny about her? Was she sleepy? Was she unsteady on her feet? Did she smell like she was smoking weed? So if the supervisor doesn't remember, didn't do anything, you might want to consider retraining and discipline of the supervisor in addition to Mary, who you might want to fire because she was using marijuana at work. But the supervisor has some responsibility in this. If Mary went to the supervisor in the morning, Mary was under the influence and the supervisor did not follow the documentation for observing signs and symptoms, which you should have a policy on that already for observing signs and symptoms at work for somebody under alcohol or drugs. You know, you fill out the form, 2 people sign it. It's very critical that you do that, and even with medical marijuana. Okay, now we've got Misty. She's a flagger on the road crew. I tried to make these situations where it wasn't all males working on the crews and all women in the offices. So we got Misty being a flagger. She's told you that she has a card, and you've got a reasonable suspicion that she's high at work. She's dancing around. She's got her, high stepper shoes on with the little things, bows in the back. She's got a little jangler. She's jangling while she's got her flag going. Well, what can you do if you have a reasonable suspicion that she's high at work? Nothing? Does anybody think you do nothing? Okay, everybody gets their pill bottle refilled. You take some action because you don't have to accommodate the ingestion of marijuana at work. And it didn't say whether she was smoking it or getting it from her pill bottle. So even if she has a card and she's legal, you can prohibit somebody being high at work. That needs to be in your policy. And flagging is probably a safety sensitive position, I would argue. And because you have a job description that says that, you can certainly take action against Misty if she's high at work. So you would handle her just like you do any of your other employees. You probably place her on suspension, then you do an investigation. You talk to the supervisor and say, hey, how come you didn't notice that Misty was high at work while she was flagging? Maybe her coworkers have seen her with her little jingle jangle boots on. Nobody's reported her, so you're going to do a whole retraining of everyone because they also failed in their duties to you. Okay, Freddie. Freddie's the next employee. Freddie has lately become very unconcerned about her job. She's taking a little nap on the desk during work hours. She has an inability to concentrate. She seems unconcerned about her job, which pays pretty well. So, what steps should you take with respect to Freddie? Somebody, raise your hand. I'm going to call on you. Okay. I'm going to call on second row back on the end. You. No, you. You win. Okay, what do you think we should do about Freddie? She's unconcerned. She's unresponsive. She sometimes is found asleep at her desk, and she doesn't have one of those little signs that says, if I'm asleep at my desk and you wake me up, all I need to say is, praise the Lord. She doesn't have that sign. Amen. No, she cannot do that. What do you do?
No.
Come on, you can do it.
No, I can. Trust me. Get a supervisor to do a second opinion and do a reasonable suspicion.
Yes. Managers and supervisors are all trained to identify impairing effects of drugs or marijuana at work. So somebody should have seen down the prayers, maybe she's got the sign up. You're right. And if they didn't, then you need to retrain your supervisors and managers, because it's their job to take care of people who are impaired at work, even if they have a medical marijuana card. Okay. John is our next subject. He's got a registration card, and you find out about it. And John's job is to drive a county vehicle, a leased vehicle, or his own car. Now, he's not going to be allowed to drive because he's got a medical marijuana card. So, do you have to accommodate him by moving him to another position? Raise your hand. Yes or no? Ma'am, you in the gorgeous green sweater. No. No? Anybody else? Oh, if it's safety sensitive, you can fire that employee if he fails the drug test. But what if he doesn't? What if you've got the Arkansas Civil Rights Act impacting that situation with John the driver? Marijuana is legal. The analysis is the same. You can not discriminate against him based on his disability. He's protected, so you have to take the following actions. You may have to place him on leave until he is able to do something else or find another job for him. Maybe, depends on the circumstances. So it's not always an automatic no. Okay. If y'all don't get this one right, you're all fired. Okay. My employees come in, it's the county judge. He comes to the county judge, all the employees, and say, we want to have a party Friday afternoon in the park, and we want to distribute our medical marijuana to some of our friends. It's a free country. Question, do you as the county judge have to allow this party in the county park after work, but it's after work hours?
The county judge invited to the party.
The county judge is invited to the party. He's the master of ceremonies. So, right now you can refuse this. Why? Because off-duty consumption of marijuana without a card is, first of all, illegal, and you can't you're not required to accommodate ingestion of marijuana in the workplace, and they're still in the workplace if they're on your property. So, you don't have to do that. Okay, another hard question. One of my suppliers, he supplies toilet paper. He's indicated that, listen, I love working for the county. I love having you guys as my client. So I want to have a marijuana party at your park. My employees seem to be all in favor of it. Duh. I'm not in favor of it. I'm the county judge. What should my answer be? Even though it's not an employee supplying the medical marijuana, it's my supplier, the toilet paper supplier. Do I have to allow this? Correct answer. That was kind of hard. First of all, no person is permitted to possess, smoke, or use marijuana in a public place, like they got the movies. And an individual is not required to allow it on their property. Off-duty consumption without a card is still illegal, and an employer is not required to accommodate the ingestion of marijuana in a workplace. So no, the toilet paper supplier, you may want to think about getting another one, by the way, because where are they getting that marijuana? Okay. Sue can't come to work because she's taking medical marijuana. That's all the fun ones, by the way. How do I handle the recertification issue when the employee returns to work? Again, you don't have to accommodate the use of marijuana in the workplace. You got to think about the implications of FMLA. I'm sure you talked about that this morning. You can require return to work forms from the doctor, and you can certainly require follow-up drug testing and certification from your MRO. So you're allowed to do that. It needs to be in your policy. Bill is a registered card holder. He has an on-the-job accident. Does the illegal drug exclusion to the workers' comp statute still apply? Hands up? Yes? No? Sir, you in the pink shirt. 3 rows back.
That's me, isn't it?
Yeah, that's you.
Love your dress, by the way.
We're both in pink today, so it's pink day. Nobody else got the card, the memo but us. Well, there's a pink, she's got pink on. She was my first callee.
I say it does.
You need to wait. We don't know what's gonna happen because the courts have got to decide on that. That's what you were gonna say. There you go. But courts in other states have dinged employers who relied solely on drug tests. So if you're gonna take action against someone, you need to have some other credible evidence to show impairment other than the drug test. That's at least what the courts have gone both ways. At this time, supposedly, MROs are hesitant to testify about positive marijuana testing because you don't really know how long it's been in the system or what the cutoff is, so we may not have doctors helping us. And for the purposes of MROs, they may not be able to testify about the detection time and the influence at the time of testing. So you want to have something else to buttress your workers' comp claim other than just the drug test. Take away, document. You all know the rule. If it's not documented, it didn't happen. Okay. Are you as an employer required to pay for medical marijuana treatments as part of your workers' comp claim? Okay, everybody's answering correctly now. You've gotten with the program. Yay. Except we need to wait to see what the courts have said. But courts have gone both ways. But the Arkansas Amendment provides that you're not required to pay the cost associated with medical marijuana unless federal law requires it to be so. So at least right now, people who are injured are not going to be allowed to claim as part of their claim payments for medical marijuana. Well, what about unemployment insurance? Have you all talked about that yet today? Is that going to be considered misconduct? Could be. Again, we have to wait for the Arkansas courts to see what they're going to say. Courts have gone both ways. It's unclear whether a positive drug test, if the person has a registration card, is going to rise to the level of misconduct in connection with the work to deny an unemployment claim. So we don't know that yet. So again, the safe route is to document all the observable signs so that you can rely on they were under the influence of work. Wasn't just because of the positive drug test. So here's some compliance recommendations. I've already harped on, I hate to be a harpy, sorry. But it's really important that you update your job descriptions to determine which jobs are safety sensitive and which aren't. It's really important that you review your substance abuse policy and update it. It's critical that you let your employees know about the medical marijuana do's and don'ts, and training your supervisors. Finding yourself a nice MRO and consider adopting a pre-duty disclosure policy. So can you read that? I need medical marijuana because all this politicking is making me sick. So far, political sickness is not a qualifying condition. But you do need to make employees aware and emphasize the importance of safety. Watch what goes on. I'm sure this office will keep you apprised of any court decisions. Don't take disciplinary action against an employee for medical marijuana without first consulting one of us, 371-9999. Questions? Yes, ma'am.
On the safety sensitive positions,
Yes, ma'am.
if they're in an office and say that an employee is working with social security numbers, adoption, juvenile records, they're private, can we make our policy say that position is a safety
Yes.
sensitive position?
Yes. She's my shill. Yes. There is a way to read into the act that it doesn't have to just be someone who's doing physical labor. That if they're, or a sheriff's deputy working with a criminal investigation, it can be someone who's working with numbers someone who's working with confidential information like social security numbers, dates of birth, voter registration information. Yes, that's why it's important that you go through all of your policies to determine which ones you're gonna label as safety sensitive. So, yeah, I agree with that. Any other questions? Yes, sir, in the back.
When is the actual date that medical marijuana will be instituted?
I can't remember. I'm sorry, I can't remember that
There
day.
is no date that I've heard.
Pardon?
There is no date.
Well, it's not gonna be for a while because we don't have all the laws in place, all the forms in place. We don't even have the committee finalized. But pretty soon, people are gonna start applying for their growers permits and their dispensary permits. I just wish I had $1 million so I could put that up, my part of what it's gonna cost. So just keep watching. It's gonna be probably in November-ish. There'll be something that'll come out on it. Any other questions? I've enjoyed this opportunity. Thank you all for allowing me to be here to speak with you today, and hey, go Pink.